you all. We're just going live, and I seek your apology in advance because there is some background sound in on my side. There is some construction work going on near my house, so please accept my apologies and excuse me for that.
All right, we are going live now on YouTube.
Okay.
We can start the session.
Okay. So again, good afternoon all. Thank you for joining with us. We are very much pleased to have you all on this session. So as you know, it is going to be a master session on Moot Court. So we don't claim that we know everything about Moot Court competition, but still we'll try to give you whatever we have learned through the last half a decade. So I and Debashish are recently passed out student from University Law College, Utkal University, Bhubaneswar. We are from 2016-21 batch. I have recently joined National Law University, Odisha for my LLM in Constitutional and Administrative Law. So I have done at least 23 Moot Court competitions, including 11 National Moot Court competitions. So I have 2 championship trophy to my credit, and I have 2-3 best memorial uploads as well. And similarly, Debashish is also a highly acclaimed mooter. He has done a lot of trial advocacy competitions as well. He has been a champion in 2 national trial advocacy competitions, and he is also a runner-up in 2 other national trial advocacy competitions. And apart from that, he has also participated in many Moot Court competitions, and he has achieved several best memorial tags to his credit. So these are basic background information about both of us. So with that, I think we are ready to start. So Debashish, can we start with the session?
Yes, we can start.
Okay. So before starting with the formal session, like what is a Moot Court competition, what are the components of a memorial, what are the basic things we should know before participating in a Moot Court competitions, we just want to have an informal talk with you all, because as I have already said that it is not going to be a monologue. I am and Debashish are not going to talk or deliver this lecture, or we are not going to deliver a monologue. So we are going to interact with you all. It is our motto. And as I have also said that many participants are from Odisha, so we will entertain questions in 3 languages, one in English, also in Hindi, and also in Odia. So we believe that language should not be a barrier in learning. So we'll definitely try to address all your queries. So before starting with the formal session, and Debashish will start with the formal session, she will explain how to read a moot proposition, because that is the most introductory part of a moot court competition. Whenever you try to participate in a national moot court competition or any moot court competition, the first step that you have to do is you have to read a moot court proposition, and you have to understand the substance of that particular proposition. And without knowing the substance, you cannot proceed to a moot court competition. So before knowing all that, I just want to ask you some questions, and it is going to be interactive session. I will ask you some questions. You have to answer me, and after that, we will proceed to the formal session. So basically, tell me what comes to your mind when you listen the word moot court. Any one of you, please volunteer and tell me what comes to your mind when you listen the word moot court. You all are law students. I suppose you all are law students, or you must be some academician or lawyer. So you must have heard the word moot court. Even if you are from first year, it doesn't matter. If you have heard the word moot court, you must be curious about it. So please tell us, what do you mean by moot court? Anyone? Please volunteer.
Demo court.
Yes, Sahil.
Demo court.
Okay, demo court. Anyone else?
It's a simulation of real court environment.
Okay, simulation of real court environment. Anyone else? Am I audible? Is the sound is very louder?
No, you are perfectly audible.
Okay. Anyone else? Sahil said it is a demo court. Tanmay said that it is a simulation of real court. Anyone else? What do you understand by a moot court? I don't want any definition, any clear-cut definition. I just want to know what comes to your mind, even a raw idea. Just tell me, what is the raw idea that comes to your
It's
mind?
basically a
Sorry.
replica of court.
Please repeat. Please repeat. It is not audible.
It's basically a replica of court.
Yes, that is also correct. It is also a replica of court. Okay, so you three are correct. It is a demo court, it is a replica of court, or it is a simulation of real court. So basically, moot court is a form of appellate advocacy. Because trial advocacy, you must be knowing about trial advocacy competitions. So trial advocacy is a form of lower court advocacy. That means that you are an advocate of a simulation of a trial court. But in a moot court competition, you have to act as an advocate in a constitutional court, like High Courts and Supreme Court. So basically, the procedures that are followed in a High Court or Supreme Court, similar procedures are followed in a moot court competition. Though not everything is followed, but still, most of the procedures are followed in a moot court competition. Like you must be knowing about read jurisdiction and many other jurisdictions. And you people must be knowing about benches, the concept of bench, constitutional bench, division bench, full bench. All these things are followed in a moot court competition. So, as the three have rightly said, that it is a simulation of real court procedure, and it is conducted by several law schools and several organizations. That you, when you are a law student, you get to know about all these competitions. You can participate in these competitions, and you can get some introductory knowledge about real court procedures. So we can say the importance of moot court is that you get to know about some practical knowledge about real court procedures. It is not actually the whole knowledge, but still it is an introductory part. You get to know about basic jurisdiction, basic procedures, and how to argue a particular case, how to make a case compilation. All these things are done in a moot court competition. So we'll go each and everything one by one. So I will first invite Debashish, my colleague Debashish Kumar Panda, to take over this session. He will make you understand about how to read the moot court proposition. We have sent you two moot court propositions. Debashish had sent you a moot court proposition this morning, and I have also sent a particular moot court proposition. The proposition that I sent, I will take an exercise upon that particular moot court proposition after letting you all know about the basics. And now you have to understand what Debashish has sent you. So Debashish will take over this session, and he will make you understand as to what are the components of the moot court proposition, and he will also make you understand what is the proposition, because we assume that you people don't know anything. We have to assume because there are many freshers. They don't know anything about moot court competition, so we cannot go with an assumption that you people know everything, and we have to just do the advanced stage training. So this is going to be a very basic training. Will act like you don't know anything, and you have to start from the very beginning. You are at the nascent stage, and we have to do everything from our side. So Debashish, please explain what is moot court proposition and how to read that, and how after reading moot court proposition one should approach the moot court competition. Yes, Debashish, it is all yours.
Right. Thank you, Jyoti Prakash, for your brief introduction about the moot court and how everything will go today, and the topics that we will discuss in our today's interaction, today's session. Now, as you said that you asked a question that what is a moot proposition. So the very basic answer to this is that there will be a host institution who will be conducting the moot court, and that particular host institution will provide the participants with a set of facts. Those set of facts will be bent in such a way that will either support one party and also support another party. It will be a well balanced set of facts, and those set of facts will be leading to a cause of action in that particular proposition, and that cause of action will go to a particular court, and that will be the court, or that will be the jurisdiction in which you will argue from both the sides. So these, there will be set of facts, there will be point of laws prescribed in that particular set of facts, all the applicable laws, all the applicable provisions, and then there will be a court before which that particular matter has to go. So all these things constitute your proposition, right? So now, as Jyoti Prakash said, we will discuss that how a moot proposition shall be read by a participant. Now, the very basic thing you all should keep in your mind, that before participating in a moot court, you frame a team with the team members with whom you have compatibility with, and then as I am saying, that moot proposition is a very important part of your moot court competition. So you should know that how you should read the moot proposition, right? Now, if anybody who is quite experienced here in moot courts, who has at least done a single moot court, can propose me some points that are very required, that are very essential to read a particular moot proposition. If someone can propose me 2-3 points, and after that I will tell you the set of principles that you should follow for that. Anybody of you can answer me with that. All right, as none of you are saying anything, I will tell you the very basic principle.
Just a minute, Debashish. So people, you have to tell what do you mean by proposition and what the word proposition justifies. You should not always tell what are the meanings of these concepts in a particular moot court competition. What is the general meaning of a proposition? Just tell us that. When you hear the word proposition, as a layman, don't take it as a mooter, as a layman, what do you mean by a proposition? Anyone, please volunteer. Please volunteer and answer us. There is nothing to worry for. You people can interact with us. And even if you answer wrong, it is not going to be a humiliation. We know that it is okay to not know something.
It is basically hello. Am I audible?
Yes, you are audible.
Yes.
It is basically a fact of the incidents that is happened. That is proposition. That is called proposition.
Yes, right. Yes, please proceed. It is all yours.
Yeah.
Is right that it is facts of a particular case that constitutes a proposition. And anyone else? Anyone else? Please volunteer. There is nothing to worry for. No one is going to humiliate.
Case. It is basically means imaginary facts which are extracted from the leading cases, which are extracted from the real cases, and it used to give to us to just draft something for the moot and all.
Yes, please take over.
Yeah. So now some of you know that what is proposition and all that, and as I said, as we both of us said, that it is an important part of your moot competition, and that is the very basic document from which everything will flow. So as our topic says, what are the necessary approach towards reading a moot proposition? Now, the first point that I will tell you is that you print out your moot proposition. You get it printed first with the rules and regulations of that particular moot competition. Because I personally feel that if you print a moot proposition, then you understand it in a better way, and that gives you a good feel to understand all the set of facts. And the another advantage of it is that you can refer to it easily whenever you want to refer. So you get your moot proposition printed. Now once you have got the copies printed, read all the rules and regulations of the moot competition and understand what are the qualification criteria provided there. And I will tell you that different moot courts have different criteria, and they will provide different moot proposition. So to have a fruitful, efficient moot participation in a moot court, you should read all these things. You should get all these things printed first and then read it serially, right? After that, the second most important thing is to read the moot proposition as much as possible, right? The obvious rule uh, of this particular thing is that you should carefully read your moot court proposition several times. And what I generally do is that out of those printed copies, I paste one in front of my study table and another one in front of the wall and one on the door. Why? Because I feel that visibility enhances familiarity. So the number of times you see the moot proposition, you will remember a particular set of facts from that particular moot proposition. Now, another thing that you should keep in your mind while reading moot proposition is that you have to remember each and every sentence of your moot proposition. And that is very, very important. Read it until and unless you are thorough with the facts of the case. You can use highlighters to mark the important parts of the moot proposition, and the moot proposition should be at the tip of your tongue, so that whenever somebody asks you a question from moot proposition, you can tell instantly that this particular fact is at this particular para of this particular page of the moot proposition. Now, what this means is that you have to read your moot problem throughout the competition and not on a single day, right? So if your competition starts today and ends 30 days from now, you should make sure to read your problem each and every single day for the next 30 days. Every time you read your fact sheet, you will get new points, new arguments, and new ideas from your moot proposition. So merely reading a moot proposition mechanically might not be of much help. So you have to make it a habit of reading the moot proposition daily and understanding it. After that, there are few pointers that I would like to tell regarding moot proposition. Firstly, make a timeline of the moot proposition. Almost all moot propositions have dates in them. Make a list of these dates on a separate sheet so that you understand the reasons as to why the matter reached before the court before whom you are going to plead. Now let's take an example. If there is a criminal case and you should make a list of the date of the incident, and then lodging of FIR, date of search and seizure, arrest of the accused, examination of witnesses, filing of charge sheet, etc. All these things would be there in a criminal moot proposition. So you have to remember all these things. Also, you have to coherently make a list of dates stating all these incidents. You have to state that on which date this particular incident has happened. So after that, you have to make a flow chart of the moot problem. Each moot problem can be broken down into a diagrammatic figure. So you have to show that what is the relationship between the petitioner and the respondent, or what are the allegations between both these parties, which can be represented in form of a diagram. It simplifies your moot problem and helps you understand it in a better way. And then thirdly, discuss your moot problem with the teammates. Now the obviousness of this rule makes it one which is highly ignored by all the teams. Even I have personally seen teams which do not discuss among themselves the moot proposition, the facts of the moot proposition. And even while judging, I have seen that the researcher would not be aware of that particular set of facts of that moot court competition. So that shouldn't be your case. Discussion of your facts is very, very important before you begin your research. Generally, when we tend to discuss the law with the teammates rather than discussing the facts. So this causes problem while preparing for your memorial as well as your pleadings, because there wouldn't be any coherence of thought between you and your teammate. And also make it a point that you should discuss the fact sheet as many times as you read it with your teammates. That will help you, that will help all the teammates of your team to be on same page. All of you would be knowing the same set of facts, what are they are provided in the moot proposition, and one would not be lacking behind in terms of knowing the set of facts of the proposition. Now, fourthly, you pay particular attention to the following parts that I will say now. The name of the court before which you are going to argue, that is very, very important. You should find out and note that first. Then history, that what all courts were approached before reaching to the instant court. And then third thing, findings of the lower court. And fourth, issues before the instant court. So you must be clearly knowing that you are appearing before, you are going to appear before which court, what are were the findings of the lower court or any other court before that particular court, and then what are the issues before the instant court. Now what is issue and how you will frame that and what are the importance of issues, that will be discussed by Jyoti Prakash in the components of memorial segment of today's session. Now, after reading your reading your moot proposition thoroughly, after dividing it into flowchart, date sheet, and all that, after finding out the issues, your before the court before which you will appear and all that, you have to identify the facts which are material and the facts which are immaterial. In every moot proposition, there will be facts that are relevant from one side and are opposing the other side. So these facts will help you in framing arguments from both the sides. So you have to find the material facts. And you should understand that all the facts that have been mentioned in the moot proposition are not relevant. Only those facts that help you in establishing your case in point are material. So those facts are your material facts. And while framing your arguments, focus on the material facts only. So don't go into immaterial facts and don't cite them per se. Now, almost all moot propositions start with a para that India, or whichever fancy name they have used, got its independence on 15 August 1947. India has a population of this. The census was done in this year, and all these things. These things are obviously not relevant or material for your case, so you can ignore them. Right. Now, suppose your moot proposition provides that Mr. X used to beat his wife, Miss Y, and one day tried to burn her by pouring kerosene, and so on and so on. So such facts are your material facts, and you should mark such facts for your further proceeding with the moot proposition and with your moot court. So you have to identify which facts are material and which facts are immaterial. Right. And after deciding which facts are material to you from your moot proposition, you have to segregate those material facts into two parts. The material facts which are supporting the plaintiff or the prosecution or the appellant, and the set of material facts which are supporting the defendant, respondents, or opposite party. So you have to segregate your material facts into these two sets. so that you will be clear that, okay, this set of facts are favoring the appellant and this set of facts are favoring the respondent, and I have to proceed with my argument on the basis of this set of facts from these sides. Right. Now the next thing is, as I said, you have to identify the issues. So if the issues have all.
This is just a minute. So people, do you have any kind of doubt till now? Do you have any doubt? Debashish has said many important things. Do you have any doubt? Please ask him. Or are we going very speed? Please let us know.
Yeah.
Regarding framing the issues. Okay, sir. How to frame the issues from that proposition? I want to know.
Yes, as I said, this particular aspect will be intricately dealt by Jyoti Prakash in the segment of components of memorial. And while he will be dealing with statement of issues, he will clearly make you understand that what are issues, how you can find issues from a set of facts, and who frames the issues, and all other ancillary parts of the issues thing. So don't worry about that. He will discuss that soon. Apart from that, if you people have any doubt regarding reading the moot proposition, how to segregate it into material and immaterial facts, or how you should divide it into flowchart or date sheet or diagrammatic figures, then you can tell me. I will make you understand again.
Sir, I have a query.
Yes. Please proceed.
Sir, how to segregate facts?
Yes.
What
Now,
material? How we should know what is material or material?
Now, after reading all the facts of your case, you will know that, okay, these set of facts I have to take for arguing from this particular side. As I said just now by giving you an example that someone is beating his wife and has tried to burn her by pouring kerosene. Right. Now, obviously, the wife would have filed a case, and that particular party will take this particular set of fact in favor of that party and against the accused, that is Mr. X or something I just said now. So that will be a relevant fact. The fact that you can take in your argument, that you can provide before the court, that on the basis of these facts, the cause of action is arising, and that's why I am before this court. And on the basis of these facts, the opposite party shall be held guilty, or this shall be the order of the court. So you have to ask question to yourself that if this particular fact is leading to arising of a particular cause of action, or if this particular fact can be taken before the court of law. Now, if it is a criminal case and you will say that while arguing India got independence on 15th August 1947, obviously that doesn't make any sense, right? So you have to see that after reading your moot proposition, that which fact is making sense to your case and which facts can be ignored, right? So in this way you have to segregate your material facts from the moot proposition, and again you have to divide those material facts into two parts. You have to see that these particular facts are supporting prosecution or appellant, as I said. Now the example that I gave you is supporting prosecution, obviously, because it is from the facts of the case you can infer that a cause of action is arising against whom? Against the opposite party. So who will take that fact in his favor? The prosecution will take that fact in his favor. So you have to segregate likewise after reading your proposition, that which facts are in favor of appellant, which facts are in favor of respondent, and likewise. So I hope I have made it clear to you.
Yes, sir.
All right. Now, one more thing you people must remember, that if you are...
Yes, just a minute. People, please keep a note and a pen ready. Just note down whatever you find useful. This is explaining many important concepts. So I think it is very important for you to note it down. So please keep a note and pen ready. So this is, please. Sorry for the interruption. Please proceed.
Not an issue. So yeah, I was saying that if you people are participating for the first time, so please don't worry that how you will segregate facts and all that, because this thing comes with experience. Now the more the number of times you participate in a particular moot court, you will know that what are the material facts of a case and from which facts a cause of action is arising and all other things that I have just mentioned. So the moot court, the ingredients or the intricacies of moot courts you will be known to you uh, by participating in them. The number of times you participate in a moot court, the more experienced you become. So that is the thing. That is the thing. So if you are participating for first time, don't worry about all these things. Thus, just keep the pointers in your mind that okay, I am getting this proposition from this moot court competition, and I have to do this work, and every thing will flow from that. So don't worry about segregating material facts and immaterial facts. As of now, if you are newcomer, if you are a first year student and have not participated in any moot court till date, so everything will come with time. Now as I was saying, you have to identify the issues. So now there are moot proposition which would have given you issues already. So in that case, you need not find any set of issues. However, sometimes issues are not given to you in your moot proposition. So identifying issues is one of the key aspects of your research. And as I said, Jyoti Prakash will deal with that in the components of moot memorial section. Now, once you have identified the relevant issues, think about the questions that a judge might ask. And trust me, this will help you in the grilling rounds. Now, the fact that I just said about the burning of his wife, you have to see that which all sections can be invoked here, which all evidences, which all sections of Indian Evidence Act can be taken by you in favor of both the parties, and all the related laws, all the related facts you should keep in your mind. You should keep asking yourself asking yourself questions that okay, from this particular line I may get a question. So if I get a question, what answer I will give to the judge. So by self introspecting while reading the moot proposition will help you in the grilling rounds, and you will be well prepared with the facts of your case and the laws. After that, you should identify the keywords from your moot proposition. Why? Because identifying the keywords correctly will help you research smoothly. So try looking for words that have been emphasized in your moot proposition, because these words generally form the basis of your moot problem. And with the accurate identification of keywords, your research will be narrowed down. Most of the moot proposition are based on landmark judgments or landmark cases that could be pending before the courts or that have been already decided by the court. So the right keywords will help you identify the relevant case laws with much ease. Now let's take an example. As the moot proposition given to you deals with Citizenship Amendment Act. If you guys have read the moot proposition, so the second case most probably deals with the constitutional validity of Citizenship Amendment Act 2019. So you can use that as a keyword and search about it. You can search about constitutional validity of CAA 2019, and you will get a lot of results from that. You can then search advantages of CAA, disadvantages of CAA. So likewise, you have to shuffle your set of keywords after identifying what all keywords you should take in for research. So reading your proposition carefully will help you in identifying the keywords. What are the most important keywords that you should use for your researching? Now suppose if you are given a case of medical negligence, so you have to put that keyword medical negligence in your Google search or whatever platform you are using for researching, and you will get relevant results from that. So identifying keywords is another important aspect of reading moot proposition. Then the next important thing that you should do is identify the jurisdiction of the case. Now, while delivering previously, I said that you should know the court before which you will be appearing. So now you should know the jurisdiction under which that court has a right to hear your petition. So this is an important aspect of reading moot problem. And by reading your moot problem, you should identify the correct jurisdiction of the case. You should be very thorough with the jurisdiction. You should know whether you are filing under original or appellate jurisdiction. You must know that under which article or section the court has the jurisdiction to deal with your matter. Because questions around this information are often asked in the preliminary rounds to test your knowledge. And I personally ask questions on the basis of jurisdiction part, and I grill participants thoroughly on that if they come with wrong jurisdiction. Now, the types of jurisdiction will be dealt by Jyoti Prakash just after this segment of dealing with proposition. And you guys, please listen to that very carefully. You should know what all types of jurisdiction are there and what are the meaning of them. Right now, let's take an example. Now, the facts of the proposition given to you say that Mr. Krishna Nil Verma, as far as I remember, has filed a PIL before the Honorable Supreme Court. Now, you should check that under which provision one can file a PIL. After getting the correct provision, which in our case is Article 32, you should see that whether the jurisdiction of the court under Article 32 is an appellate jurisdiction or original jurisdiction or an extraordinary original jurisdiction or any other kind of jurisdiction. In our case, it is original jurisdiction, or you can say extraordinary original jurisdiction, because it is a PIL as far as I remember. So you should know, you should also know the meaning of all kinds of jurisdictions in this case. So while reading down your proposition, that should strike your mind instantly that okay, Mr. X has filed PIL, it is original jurisdiction. Mr. Y has filed an appeal, it is an appellate jurisdiction. So likewise, you should know that what is the nomenclature of the jurisdiction under which you will be appearing in the moot court competition. And again, as I said, what is the relevant provision for that? So you have to check out all these things after reading your proposition. Now, these were the important points which you should keep in your mind while reading down your proposition. First, get your copy printed. Then next, read it as much as possible. Third, you should find material facts and immaterial facts. Then next, identify the issues. Then next, identify the keywords. And lastly, identify the jurisdiction of the case of the court before whom you are going to appear. So these were 6-7 important points that you should keep in your mind while reading down your moot proposition. Now, if you people have any doubt regarding reading moot proposition, please ask me so that we can clarify it as and here. Also, if you people are shy enough to ask question on Zoom, you can type down your question on chat box, or you can type down your question on the WhatsApp group. We will entertain that.
So, SLPs are covered under which jurisdiction?
All right. Please tell me the full form of SLP.
Special leave petition under Article 136.
You already gave the answer, I guess. Article 136 of the Constitution.
But like, is it a original jurisdiction or what exactly is it?
This particular aspect will be dealt by Jyoti Prakash, as I said. However, I will give you the answer to this in a brief. Special leave, whenever you file a case under as a special leave petition, and as you said, under Article 136, that will be your extraordinary appellate jurisdiction. Now, from where I am getting this, the answer to this will be given by Jyoti Prakash. right? So he will give answer just now because his
Okay,
segments are coming right now.
let me answer it now. So the question was SLP comes under which jurisdiction? So as he rightly said, it is explained under Article 136, the special leave to appeal, or it is also roughly called as SLP, special leave petition. So for knowing what kind of jurisdiction it is, you have to understand as to when you can use that particular provision. Now let us go to the particular article which talks about special leave petition. So I will share my screen and I will show you what is Article 136. So Debashish, can I take my part from this particular question?
Yes,
Or
yes, my
you will
part is
answer?
already done. Now, if someone has any question related to moot proposition, they can ask in between.
Okay.
And we
So,
will address that.
yes. So participants, if you have any question relating to moot proposition, then please ask it now. Otherwise, I will start explaining what is SLP and then I will go to the components of moot memorial. So I will answer it just now. So before that, if you have any question relating to how to read a moot proposition, what should be the approach, how to segregate the relevant facts and irrelevant facts, all these kind of questions can be asked now, and Debashish will definitely entertain them. You can open your mic. There is no issue. There is no humiliation. If you don't know something, it is quite okay. We also don't know many things. And one thing I also want to tell you all that, as I have already said, that we don't know many things and we are also susceptible to committing wrong. So you people can rectify us if we go in a wrong direction or we explain something wrong. You people are really free to tell us that we are saying something wrong. We should not mislead anyone because we are not that much experienced. We are just graduated from our law schools. So it is quite okay if we don't know anything and if you rectify us. Okay. You can tell us if you have any doubt relating to fact sheet, how to read fact sheet, how to segregate relevant and irrelevant facts, how to carve out the issues. These are technical things. So do you have any doubt? Especially the people from the very first year or second year, those people have many doubts relating to these aspects.
Good
Feel free to
afternoon,
ask
sir.
us. Yes, yes. Yes, please.
Good
So
afternoon, sir. Yes.
regarding the issues, like how to carve out the issues.
Okay. So there was this.
So
Shall I tell that or you will tell us?
You will deal that right now only, as you said. So
Okay.
that please wait for that. That will be dealt by Jyoti Prakash, as I said repeatedly. So don't worry. We will cover everything. One another doubt was coming from someone. So if we
Yes.
can ask, I guess.
Yes, sir. Good afternoon, sir. So, like for example, when we are doing a research work, even if we open a book or any site, and in case when we are in first day, we haven't read that particular subject to which the proposition is related. So it becomes quite difficult to connect the dots as well. Like this is in IPC, then in CRPC also the procedure is given. तो CRPC को भी connect करना है फिर IPC, then sometimes like how to know, even if we haven't read the subject, so how to know where we have to go and how to go, like that particular thing, since we are in first year we haven't read that subject. So
All right. This particular aspect will be dealt by me under the heading research methodology, and I have a particular good answer prepared for this. So you have reminded me of that. I will surely deal with this after Jyoti Prakash completes.
thank you so much, sir.
So any other doubt? So we are taking more and more time because we know that people have many doubts. They're hesitant to ask us. Please don't feel hesitated. Oh, please open your mic. You can use any language, English, Hindi, or Odia. There are many Odia people. You can also use Odia language. We will translate it for you. Feel free to ask us anything.
Jyoti Prakash, one question is coming on our live session on YouTube.
Yes.
Vaishno Priyakar asked that how can we distinguish between our points in against points and in our Acha. She is asking that how to segregate the points which are supporting one and which are against one. Right. So basically,
Yes.
as I said, that you have to segregate material facts into two parts. One that will be favoring the party who is bringing the case, and another one supporting the party who will respond to that or who will defend the cause of action brought by the first party. Right. So now, as I said, you have to introspect after reading your facts. You have to hear in your mind that, okay, I am reading this particular fact, and you have to farsight that if that particular fact can be taken in favor of the party who is bringing the case, or if that particular fact can be taken by the party who is responding. So you have to do that introspection in your mind. You have to think on that particular point of fact, particular para again and again. And after that only you can deduce that, okay, this set of facts can be taken by me if I am bringing the case before the court, or this set of facts can be taken by me if I am responding the cause of action brought by the plaintiff or appellant. So these things come, this thing will come after self introspection, after reading the moot proposition. So you have to think on those lines of moot proposition again and again. You have to ask yourself question, as I said, that can I take this particular fact in favor of me? Is it going in favor of me if I will take that before the court of law? If not, then that is a point against you. If yes, then that is a point that you can take in your favor. So that you have to understand after reading your proposition 2-3 times. You will surely get that, okay, these set of facts will be taken by me when I will be the party bringing the case, or this set of facts will be taken by me when I will be responding to the allegations. So this process has to be done by self introspection way. So there is no rocket science, trust me. You can easily get that after reading your proposition. So you have to read your proposition carefully to find that out. Yes, Jyoti Prakash.
Yes. Anyone else? Do you have any question? We are taking more and more time because we know people are in their introductory years of law school. They can ask us anything, anything.
Hello, sir. I have
Yes.
a doubt.
Yes. Please proceed.
Sir, can you give some example of open civil cases? How to deal with civil cases?
How to deal with a civil case? Right. See, now if a moot proposition is on a civil case, then it will most probably be a constitutional case first. Then there are some moot courts which deal with niche area of laws like IPR, arbitration, and when you deal with all these laws, non-contentious laws, you will obviously find CPC in that, and CPC is your civil procedure code, and all these will be civil cases. Now, if that is not coming under CRPC and IPC is not involved, every other case is basically a civil case. Right. So how to deal with that? Now, if you get a civil case proposition of a moot court competition, you have to read all the relevant provisions which are invoked. Now, suppose Arbitration Act has been dealt by that particular moot proposition, then you have to see that which provision of Arbitration Act is invoked, whether it is section 9 or whether section 34 or whether any other section of Arbitration Act. You have to find that particular section first, and after that you go to Arbitration Act commentaries and read those particular provisions. And there are various other ways how to go with the research of a moot proposition that I will deal with. So that will apply on both civil cases and criminal cases. I will tell you the general principles, and you can apply that likewise, whichever moot proposition you will be dealing with in your prospective moot.
Thank you, sir.
And one thing that I want to add here, in criminal cases, the standard of proof is beyond reasonable doubt, beyond all reasonable doubt. And in civil cases, it is preponderance of probability. In a criminal case, you cannot say that you have proved most of your points. You have to prove all of your reasonable points. You cannot say that some doubt remains and every other thing has been clarified. You have to prove each and everything before convicting a person in a criminal case. But in a civil case, it is preponderance of probability. It means whose side has more weight, he will win the case. It is not like criminal cases where you have to prove all your reasonable doubts. You have to just prove that your side is heavy, and hence you should be given the benefit of that particular case. So the people who are in the first year and second year must note these two concepts, like preponderance of probabilities and another concept. And preponderance of probability is used in civil cases, and in criminal cases the standard of proof is beyond reasonable doubt, all reasonable doubt. Okay, so now I'm going to the questions that was asked to Debashish about special leave petition. So let us go to that particular provision, then we will discuss what it is. So can anyone open your Bear Act? Please, I will actually request everyone to open your Bear Act, the Constitution Bear Act. Please, everyone, please open your Constitution Bear Act. If it is available in hard copy, then please do that. Otherwise, please open your Bear Act in soft copy, PDF. If you want us to send you the soft copy of Constitution Bear Act, then we can also do that. Debashish, please send the soft copy of the, yes, Debashish will send in the group. So please open that Bear Act and go to the provision, Article 136. Everyone. Someone please volunteer and read it out for me. What Article 136 says. Someone please.
So
Yes.
can I?
Please.
Special leave to appeal by the Supreme Court. Notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India.
Okay.
2. Nothing in clause 1 shall apply to any judgment, determination, sentence, or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces.
Perfect.
Thank
So
you, sir.
as the heading of the Article 136 says that it is special leave to appeal by the Supreme Court. The word special has been used. So it has some significance. It is not only superfluous word, it has some significance. And why this special leave has been used, I will explain. First thing, in the clause 1, you can see, as he read it out for you all, it says that notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal. So there are some most important words that are used here. One thing is Supreme Court may, in its discretion. It means it is not compulsory for the Supreme Court to grant you leave to appeal. Unlike Article 32, in a writ petition, the Supreme Court doesn't have any discretion. It has to entertain that particular petition because it deals with fundamental rights. So Supreme Court doesn't have any discretion, or it has some discretion, but it cannot outrightly cannot say that it is out of merit and will not entertain your petition. That is not so. So in a case of special leave petition, there is some discretion vested with the Supreme Court. It means the Supreme Court either can accept your case or can reject your case. So special leave to appeal. One thing it is written that special leave to appeal. So it is a kind of appeal. It is not a writ petition. It is not a direct petition to the Supreme Court. So the most important thing to note here is that it is a kind of appeal. And by appeal, I mean there must be some lower forum. You must have approached some lower forum before approaching to the Supreme Court under Article 136. And it is written in Article 136 before which forum you can appear before approaching to the Supreme Court under Article 136. Debashish, am I audible?
Yes, yes, you are audible.
Okay.
So there is a lot of disturbance coming from your side.
Yes, I'm sorry for that. And there are some construction works going on near my house, so I cannot help. So I think if I am audible, you can hear me. Please try to get it. I'm very much. I'm sorry for that. I cannot do anything. Okay. So Article 136 says in its discretion. Okay, discretion. So the discretion is used by the Supreme Court to either accept or reject your appeal. So any kind of case can go to the Supreme Court through this particular provision. So it is written the special leave to appeal from any judgment, mark the word any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. It means even an order passed by a judicial magistrate first class can also be appealed under this provision to the Supreme Court. But in real practice, it is never done so because there is some hierarchy of courts. So we have taken this point as hierarchy of courts. We will explain what is the hierarchy, and we cannot just bypass the hierarchy just like that. So, but under Article 136, you people must know that you can even appeal an order passed by or a judgment passed by a JMFC or judicial magistrate first class or a district judge directly to the Supreme Court, even without approaching the higher courts like High Court. You can even bypass that High Court. But one thing you have to do, you have to satisfy the discretion of the court. You have to satisfy why your case requires the attention of the Supreme Court. If you are able to satisfy the court that yes, it is a very important matter, if it is not entertained by the Supreme Court, it will cause prejudice to us. If you can do that, then Supreme Court will allow you. And it is completely upon the discretion of the court. They have to give reason as to why they are outrightly rejecting your appeal or why they are accepting your appeal. They have to give reason. But you have to convince the court. And you will get some 2 minutes or 3 minutes to convince the court that your matter deserves some attention of the Supreme Court. You must be knowing about miscellaneous days. So I'm going a bit out of the concept of moot court to make you understand about all these concepts. You must be knowing about miscellaneous days. In Supreme Court, there are 2 miscellaneous days. One is Monday and one is Friday. In these 2 days, only SLP matters are heard, and constitutional bench matters are heard. So in miscellaneous days, Supreme Court here's the special matters. So it tries to admit matters, it tries to admit some matters, and it also rejects all other kind of matters which are not that much necessary. And you must note that 80% of matters in special petitions are rejected. So you have to make out a case, a very deserving case, so as to maintain your matter in the Supreme Court. Okay. Okay. Monday and Friday. Okay. So I was trying to say that Monday and Friday are known as miscellaneous days in the Supreme Court of India. And these 2 days are used for hearing special petitions. Okay. These 2 days are used for hearing special petition in the Supreme Court of India. So in these 2 days, there are multiple benches in the Supreme Court which hear specially matters. They hear the primary arguments of the specially matters, and they either admit that particular matter or outrightly reject that. But they have to give reason as to why they are rejecting a petition, special petition, which is also known as appeal by special leave. So as he was asking as to what kind of jurisdiction it is clearly an appellate jurisdiction. So another thing that is mentioned in the special leave provision is that you can appeal any order, any judgment, or any decree under this provision. And any decree, any order, and any judgment means matter, or a judgment or order in a civil matter. So it can be of any matter. So if you are appealing to the Supreme Court in criminal matter, then it will be a criminal appellate jurisdiction. Okay. If you are appealing a civil matter to the Supreme Court through SLP, then it will be known as civil appellate jurisdiction of the Supreme Court. Okay. Did you get my point? Who was asking that particular question? I forget.
Yes, sir, it's clear. Thank you.
Yes. So it is an appellate provision. I will repeat once again. It is an appellate provision. If a particular matter of criminal nature has been appealed to the Supreme Court under Article 136, then it will be known as civil appellate jurisdiction. If a criminal matter has been appealed, then it will be known as criminal appellate jurisdiction. Okay. So this is all. Yes.
So, like, one more doubt, like, which bench would deal with the SLP? Would it be a division bench, constitutional bench, especially when we challenge like any constitutionality of an act which was given in like the moot proposition?
Okay. So
the second one.
thing. Okay. I got it. So one thing, if you are given a proposition where constitutionality of a particular provision is challenged, then it will not be a SLP. It will be a writ petition, because if constitutionality has been dealt, then there will be some involvement of fundamental rights. Then you have to go under Article 32, not under Article 136. Okay, so this is not a SLP matter. It is a matter coming under Article 32. It will be a writ jurisdiction. So all kinds of constitutionality, you can see the matters in the Supreme Court which have dealt with many constitutionality matters. You can see all of them are writ jurisdiction, are under writ jurisdiction. Or otherwise, if something is challenged in a high court, for example, if a particular provision, GST Act, is challenged for being violative of Article 14, 19, 21 in our High Court, in my state High Court, in the Odisha High Court, and it was struck down. If I challenge that particular act of striking down that particular act, then I can challenge it in the Supreme Court through SLP. That will be a civil appellate jurisdiction. But if I am directly challenging it in the Supreme Court, then I have to go under Article 32, not under Article 136, because it is not an appeal. Under an appellate provision, you cannot challenge the constitutionality of an act or some provisions of an act. Okay. Is it clear?
Yes, sir. And so the bench would be a division bench or a constitutional bench?
Okay. So in an SLP matter, it is usually a division bench. In the Supreme Court of India, until 2020, I believe, until 2020, there was no concept of single bench. In high courts in different parts of the country, you can find single benches. But in the Supreme Court, you can never find a single bench until 2020. For the first time in the year 2020, a single bench was constituted, and it was especially constituted for hearing matters relating to transfer of cases. You must be knowing transfer provisions. Supreme Court can transfer a particular case from one court to other court. So for dealing with those matters, a single judge bench was created for the first time in the year 2020. Before that, the minimum number of judges required to constitute a bench in Supreme Court was 2. So it is usually heard by a bench of 2 judges. That is known as division bench. So SLP are generally heard by 2 judge benches. If it involves some questions of constitutional interpretation, then it can be referred to the Chief Justice of India. The Chief Justice of India can assign this matter to a higher bench. And when there is some matters relating to interpretation of constitution, then usually a bench of 5 judges or more is to be created by the Chief Justice of India. Otherwise, if the SLP is relating to some criminal provisions or some civil provision, then it will be heard by 2 judge benches or a 3 judge bench known as full judge bench, and it will be disposed of by them only. Is it clear?
Yes, sir. Thank you.
Okay. So, do you have any doubt? Anyone else? Do you have any doubt relating to Article 136? Actually, I was planning to deal with this particular provision sometime later, but she asked me, and it is really a very important provision. It is the most important provision you will find in a moot court competition. Okay. So do you have any doubt? And one thing more. Yes, please.
Sir, I have a doubt.
Yes.
Sir, in Article 136 SLP, what types of cases we generally deals about?
Okay, so if you read the words that are used in Article 136, then you can find these kind of words. I am reading out. So it says that grant special leave to appeal from any judgment, decree, determination, sentence, or order. So it doesn't classify as to which cases can be entertained under this provision. It can be of any type, I mean any type. It can be of any type.
Sir, it's both for criminal cases and as well as civil cases also.
Yes, exactly. It is
Okay,
both
sir.
for criminal and civil cases. There is
Yes,
no
sir. Thank you,
classification.
sir.
Yes. Any kind of cases, even appeals from tribunals. You must be knowing about tribunals like National Green Tribunal. There are other kind of tribunals, TEDSAT. We have SEBI. These kind of administrative authorities. The appeal from these administrative authorities can also be appealed under Article 136 to the Supreme Court. And second,
Okay, sir, thank you.
yes. And the second clause says that nothing in clause 1 shall apply to any judgment, determination, sentence, or order passed or made by any court or tribunal constituted by or under any law relating to armed forces. So only exception to Article 136 is armed forces. So a tribunal is there to deal with armed forces matters. So the orders or judgment passed by armed forces tribunal cannot be appealed to the Supreme Court under Article 136. So this is only exception. This is the only exception. Except that each and every kind of matter can be challenged in the Supreme Court under Article 136. It is the most
Okay,
important.
sir. Thank you, sir.
Yes. Thank you. Thank you for asking this question. So this is the most important provision you will find. So people, I want you all to note down this provision. And if you have any doubt in the interpretation of this provision, you can ask me. I will definitely try to address. Okay. If you don't have any doubt, then I will go to next provision. Okay. Then let's deal with jurisdiction first. Then I will go to the components of memorial. So I have dealt with 136 there, that is special repetition. Let's go to the second most important provision. Actually, it is the most important provision that I am going to deal now. But if you go with practice, then Article 136 is most frequently used provision in a moot court competition. So you people need to be thorough about Article 136 first. Okay. So now let's deal with Article 32. Let's deal with the jurisdiction of the Supreme Court first. Then we will go to some jurisdiction of the High Court. So anyone, please volunteer and read Article 32 for me.
So should I?
Sure. You can proceed.
Remedies for enforcement of rights conferred by this part. First, the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed.
Okay.
Second,
Please.
the Supreme Court shall.
Please stop. I will explain, then you will read. Okay. Thank you. So it says the headline of the article is remedies for enforcement of rights conferred by this part. And by this part, it means which part? Can anyone say? Can anyone tell me which part it is telling about? It is talking about the
part 4.
Part 3.
Yes. And part 3 deals with which provisions?
Fundamental rights.
Right. So it deals about part 3 and it deals with fundamental rights. So it says that remedies for enforcement of rights conferred by this part. So if your fundamental rights are infringed or abridged, then you can directly go to the Supreme Court under its original jurisdiction under Article 32 for the enforcement of your fundamental rights. So the provision says that the right to move to the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. So the Supreme Court is duty bound. It is the guardian of fundamental rights. So it is duty bound to entertain your petition. It has to hear your petition when you say that you allege that your fundamental rights are violated. It is duty bound. It cannot say that I will not hear you. It can only say that if you have not approved the lower court, that is the high court, then you can approve that. But if it is not desirable in the facts of your case, then I can also entertain your petition. It is so in the provision. Okay, so second clause of that particular article says that the Supreme Court shall have power to issue directions, orders, or writs, including the writs in the nature of what kind, how many types of writs we have? Can anyone tell me?
Five.
So we have 5 types.
Okay, what are they?
So first is habeas corpus, second is mandamus, third is prohibition, fourth is quo warranto, and the fifth is certiorari.
Sure, yeah, very right. So in our country we use 5 writs. In common law countries they use some other kind of writs as well. We are also common law country, but by common law country I mean UK. It is the mother of all common law countries. So they use some other kind of writs as well, but we use these 5 kinds of writs: habeas corpus, mandamus, certiorari, quo warranto, and prohibition. All these writs we use to enforce our fundamental rights. The Supreme Court can direct or issue any of these writs, having regard for the acts and circumstances of the case, for enforcing the fundamental rights of citizens. So, okay, after writing about writ, okay, one thing more is written in this article. You can see the Supreme Court shall have power to issue directions or orders or writs. So there is some misconception within the legal fraternity, especially among the students, that Supreme Court can only issue writs for enforcing fundamental rights, and Supreme Court doesn't have any other power under Article 32. And or in other words, I can say people believe that when we approach Supreme Court for enforcement of our fundamental rights, then they feel that it is mandatory for the Supreme Court to issue a particular kind of writ. And if it doesn't issue any kind of writ, then it cannot enforce any kind of fundamental rights. It is a misconception. It can either pass a direction, it can either pass an order, or it can pass a writ. Any kind of remedy it can pass. So either it can pass an order. A particular order can be passed that please enforce these rights of this particular citizen who has alleged that his fundamental rights are violated. It can either issue directions. It can issue directions. We have seen in many cases directions are issued by the Supreme Court to enforce the fundamental rights. Or in other cases, it can also issue writs. These 5 writs. Okay. The third clause says that without prejudice to the powers conferred on the Supreme Court by clause 1 and 2, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2. So the Parliament has power to extend this writ jurisdiction to other courts as well, including the subordinate courts. But till now, Parliament hasn't done so. So till now, writ jurisdictions are conferred only upon Supreme Court and High Courts. You cannot find writ jurisdiction in the district courts or subordinate courts. Okay, so writ jurisdictions are basically used for enforcing fundamental rights in the Supreme Court. But there is a fundamental difference between writ jurisdiction of the Supreme Court and writ jurisdiction of the High Courts. And which article says that High Court has some writ jurisdiction? Can anyone tell me?
226.
226.
Yes. Can anyone read it out for me? What Article 226 says? Anyone can volunteer and read it out.
So can I?
Yes, please.
226 says power of High Court to issue certain writs. Notwithstanding anything in Article 32, every High Court shall have power throughout the territories in relation to which exercises jurisdiction to issue to any person or authority, including in appropriate cases any government within those territories or directions, orders, or writs, including writ in the nature of habeas corpus, mandamus, provision, quo warranto, and certiorari, or any one of them, for the enforcement of any of the rights conferred by Part 3 and for any other purpose.
Okay, okay. That's it. Thank you. Okay, so the words that are read out by him, it clearly says the power of High Courts to issue certain writs. And the words, mark the words. Please, everyone, open your Act and read the first clause of Article 226 and mark the words. Whatever I say, please mark the words. Notwithstanding anything in Article 32, that is the writ jurisdiction of the Supreme Court. Every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue any person or authority, including in appropriate cases any government, within those territories, directions, order, or writ. As we have discussed in the case of Supreme Court, the Supreme Court can issue either order, it can also pass some directions, it can also pass some writs. So the similar thing is also with the High Courts. They can pass any of this. It is not compulsory that you have approached before the Supreme Court or High Court under Article 32 or 226, then they are duty bound to pass some writs. That is not so. They can pass either order or some directions or writ. It is not compulsory that in every case writs will be issued. Okay. So one thing more that has been written in the first clause that differentiates the jurisdiction of the High Courts from the jurisdiction of the Supreme Court and makes the jurisdiction of the High Courts more broader than that of the Supreme Court. It says that for the enforcement of any of the rights conferred by Part 3 and for any other purpose. Supreme Court, we have read Article 32. It says for the enforcement of the rights conferred under Part 3, that are fundamental rights. But in this particular clause of Article 226, it says that for enforcement of any of the rights conferred by Part 3, means the fundamental rights, and for any other purpose. It means not only it is confined to fundamental rights, these remedies like order, writ, or directions can also be issued if there is some infringement of legal rights or any other kind of right. So the jurisdiction of the High Court in matters of writ is broader than that of the Supreme Court, but it can only exercise the power within the territory upon which it exercises its jurisdiction. If I am sitting in Odisha and I have Odisha High Court, then it can only exercise its jurisdiction within the territory of the state of Odisha. It cannot say that some authority from Meghalaya or Mizoram or Sikkim, please do that or do this, because it is not within the jurisdiction of my High Court, the High Court of Odisha. So they have to confine themselves within their territorial jurisdictions, but they can pass writs, orders, and directions in appropriate cases, not only for enforcement of fundamental rights, but also for enforcement of legal rights. Is that clear? Anyone has any doubt? Anyone? Please feel free. Please ask me if you have any doubt relating to Article 32 or 226. The writ jurisdiction is one of the most important jurisdictions that you will use in moot court competitions and also in real life. So you people must be knowing about a concept called PIL. What does it mean? Can anyone tell me?
Public interest litigation.
Yes. So can anyone tell me was PIL there in our original constitution, or it was developed later on?
So it was addressed by P.N. Bhagawati in the case of MC Mehta versus Union of India.
It was developed later on.
In which case, sorry, it was not audible.
Sir, MC Mehta versus Union.
MC Mehta, okay. Anyone else? Can anyone tell me in which
Sir,
case? Yes.
Sir, it was
Sir, Bhopal
developed
gas tragedy
later on. Yes, so Bhopal gas tragedy cases.
Okay. So it was in the year, in which year? MC Mehta, Bhopal gas tragedy. There are
Please,
several
you may
multiple
forgot.
cases. Sorry, please repeat.
Sir, forgot the year. Please, you may.
Okay, okay. There are multiple cases involving Mr. MC Mehta. So it
Sir, no,
is.
it was it was the Bhopal gas tragedy case, sir.
Yes, yes. And in which year Bhopal gas tragedy happened?
1984.
Yes.
Sir,
So
it's 1984.
yes. Okay. So it is quite late. Even before that, the concept of PL was developed and was also used.
Sir, Hoshenara Khatun case.
Yes, right. Who said this?
Sir, Shraddha.
Yes. Thank you, Sudha. It was for the first time the PIL jurisdiction was used in the case of Hoshenara Khatun versus State of Bihar in the year 1979. But there is also some misconception that the genesis of PIL was also shown here. It is not so. It is for the first time that the PIL jurisdiction was used in the case of Hoshenara Khatun versus State of Bihar. But the genesis lies in one in another case. In another case, can anyone tell me what is that another case? Yes. The first time the jurisdiction was used, it is quite correct in Hoshenara Khatun versus State of Bihar. But the concept was not developed in the case of Hoshenara Khatun. The concept, the genesis of this concept lies in another case. Can anyone tell me what is that case? Anyone? Okay. You people will search a case named Mumbai Kamgar Sabha matter. I will write it down for you. Devasis, can you write it for me in the chat box?
Yes, sure.
Yes. Devasis will provide you the case. Mumbai Kamgar Sabha case. It was in the year 1976, if I am not wrong. It was in the year 1976 in the case of Mumbai Kamgar Sabha. The concept of PIL was developed by Justice B.R. Krishna Iyer. It was first used, it is widely believed that it was first used by Justice Prafulla Chandra Natwallal Bhagwati, but there is some confusion regarding this particular fact. And as per the records available, in the year 1976, in the case of Mumbai Kamgar Sabha versus Abdul Bhai, if I am not wrong, in this particular case, Justice B.R. Krishna Iyer, yes, Devasis has provided the case. You can search it from Indian Canon or any other database if you have. So in this particular case, Justice B.R. Krishna Iyer is a legendary judge. You must read his judgments. He's a legendary figure in the Indian judiciary. He has tried to develop this concept called public interest litigation. And later on, Justice P.N. Bhagwati joined hand with Justice V.R. Krishna Iyer, and they collectively developed this concept. And it was for the first time used in the year 1979 in Hoshenara Khatun matter. And Bhopal case tragedy is one of the most important cases under PL jurisdiction, but it is not the first case. Okay. People, you have any doubt regarding these cases or the concept called PIL? Any doubt? Please ask me. Anything you want to ask me, I will try to address. Anyone? Sahil? I will take the names. Please tell me if you have any doubt or say no.
No, sir, I don't have any doubts.
Okay.
So can I?
Mona Lisa? Yes, yes. Someone is telling something. Okay. Please tell.
So thank you, sir. So actually, here only in Article 226,
Yes.
it has been mentioned that we can file the writs for the enforcement of any of the rights conferred by Part 3 and for any other purpose. So that for any other purpose, so that purpose, what does it stand for? Like anything we can file, like
Yes.
Should not be
So
fundamental right, then also we can file.
yes, yes. So that is really an important concept. And if you want to know about the concept in detail as to what constitutes that any other purpose, you have to read the precedential development, what has been done after 1950. Sorry for the interruption. There is very huge noise in my area. There was this. I will just take 1 minute break because I want to just stop that particular noise.
Yes, yes, please.
Yes, yes. Yes, yes. I think the noise is not there. Am I audible?
Yeah.
Yes. To understand the development of this particular word, that is any other purpose, you have to read the precedential development that has happened after the year 1950. You know, in several cases, the Supreme Court as well as different high courts have interpreted this particular word like any other purpose. So they have actually interpreted this word to mean that any other legal rights, okay, not only the fundamental rights, but any other legal or constitutional right. So basically, it means any right conferred upon you under other statutes except from the Constitution, or any other provision in the Constitution except Part 3. If you have any right, for example, you can take Article 300A. It says about right to property. So if your right to property has been violated, if your land has been acquired by the government and you are not provided with your due compensation, then you can also approach the High Court, your jurisdictional High Court. In which state you are residing, you can approach the jurisdictional High Court under Article 226 and can say that, your lordships, any other purpose means also the legal and constitutional right. It doesn't mean only the fundamental rights, though Article 308 doesn't come under Part 3, though my right to property doesn't constitute a fundamental right, still it is a constitutional right. And under Article 226, I have a due right to approach for you and tell that I have been aggrieved by the action of the government. They have not provided me compensation. So I can enforce this particular right under Article 226 as well, because there is a word called any other purpose. It's not only confined to Part 3 of the Constitution. So is it clear?
Thank you, sir. Yes, sir. Thank you so much, sir.
Sorry, it is not audible. Please be louder.
Yes, sir. Yes, sir. Thank you, sir. It's clear.
Sorry, it is really not audible for me. There's this, can you tell me?
Yeah, she is saying that she has understood that.
Okay, okay, okay. My apologies for the noise. I cannot help actually. Okay. So I was explaining 32. Okay. Let's then go to Article 133 and 134. We'll quickly wrap it up because they are not frequently used provision in a moot court competition, but still we should know about the civil appeal and criminal appeal provisions that are provided under the Constitution. So Article 133. Can anyone read it out for me? Article 133. Anyone?
So should I?
Sure, sure. Proceed.
Appellate jurisdiction of Supreme Court in appeals from high courts in regard to civil matters. First, an appeal shall lie to the Supreme Court from any judgment, decree, or final order in a civil proceeding of a high court in the territory of India if the high court certifies under Article 134A.
Yes. Thank you. So in this, under this provision, you can find the word that an appeal shall lie to the Supreme Court from any judgment, decree, or final order of the High Court in the territory of India, whether in a civil. Sorry. I was reading a different provision. Sorry. The headline of Article 133 says that appellate jurisdiction of Supreme Court in appeal from high courts to in regard to civil matters. Okay, so it says that an appeal shall lie to the Supreme Court from any judgment, decree, or final order in a civil proceeding of a high court in the territory of India if the high court certifies under Article 134A. So you can find many civil appeals under Article 136. Actually, if you actually analyze the data that we have with us, then you can find most of the civil appeals are filed under Article 136. And that also the same with criminal appeals. Many of these criminal appeals, most of the criminal appeals are filed under Article 136 rather than Article 134, which actually deals with criminal appeal. So we have to find out reason as to why the civil and criminal appeals are filed under Article 136, more in 136 and less in these original provisions. Those actually provide for the right of appeal under Article 133 and 134. So can anyone tell me, there is a provision, there is a line which justifies as to why appeal is not filed, appeals are not filed under Article 133 and 134, and more appeals are filed in Article 136. Can anyone tell me what is the reason as to why people are keen to file appeal under 136 rather than under Article 133 and 134 in their matters? Sorry, Debashish, am I audible?
Yes, yes, you are audible.
Yes, I lost my connection. Sorry. So I was asking why people are keen to file appeal under Article 136 more than under Article 134 and 133. Can anyone tell me? The answer lies in the bare provision of that particular article, Article
So can
133
I?
and 134. Yes, please.
So maybe, sir, actually, I don't properly know the answer, but it's just I want to guess that because it in Article 33 it involves a substantial question of law, which is not mentioned in 136. So
Yes, yes. It is one of the reasons. Actually, you are telling the right thing. It is one of the reasons. Article 136 deals with substantial provisions of law.
any matter can be taken by Supreme Court, but in 133 there means it is involving that it should be a substantial question of law. But in 136, I think they can take any case if that is also decided by Supreme Court only.
Yes, that is one of the reasons. But what is the primary reason? That is one of the reasons. Yes, that is quite correct. That there is a requirement of substantial question of law. And there are some other requirements as well under civil appeal and criminal appeal. But in the first clause, there
Could I
is.
try?
Yes, yes, please.
Yeah, I believe because the certificate from the High Court is required in Article 133, whereas it is not required under Article 136. It becomes easy and it is not so time consuming to file it under 136. So I believe that's the reason.
Yes. Thanks, Neha. You are quite right.
Sir, may I?
Yes, please.
Sir, I think the cases were decided very fastly under this article. I think so.
Under Article 136, right?
Yes, sir.
Okay. If you go by the statistics, then you can find the matters under Article 136 and also under Article 133 and 34 are decided in within a similar time frame actually. So I don't think that is a very correct answer, but still a very good guess, I must say. But what Neha said is actually quite correct. There is a requirement of certificate from High Court for appealing under Article 133 and 134. If you are going to appeal in the Supreme Court in a civil or criminal matter, then you have to obtain a certificate from the particular High Court of whose judgment you are going to appeal in the Supreme Court. So if the High Court certifies that yes, your case is a deserving one and it should be appealed in the Supreme Court, it deserves the attention of the Supreme Court, it deserves the time of the Supreme Court, then you can appeal under Article 133 or 134. But if it denies to give you a certificate, then you are not eligible to appeal under Article 133 and 134. So people are more keen to go and appeal to the Supreme Court, even those matters which are falling under Article 133 and 134. They are still keen to go and appeal under Article 136 because it doesn't require a certificate. And also partially it is correct that it consumes certain less amount of time. I don't know whether it is quite arguably true or not, but still it can be a good reason, I think. I have to verify the data actually. So, okay. So we have discussed Article 132, 133, 136, 32 and 226. So we'll now discuss another important provision that is provided under Article 143. Can anyone tell me what Article 143 says? 143. Anyone?
Power of President to consult Supreme Court.
Yes. Okay. So Article 143 says about advisory jurisdiction of the Supreme Court. So whenever there is a doubt in the mind of the President of India that a particular legal point is not actually clear, it is not apparent, and some kind of advice should be sought from the Supreme Court, then he can refer that matter to the Supreme Court under Article 143. And whenever a matter is referred to the Supreme Court under Article 143, the Supreme Court is duty bound to answer that. And it is also a matter of practice that whenever such kind of reference is made to the Supreme Court, the Chief Justice constitutes a bench of at least 5 judges, constituting of at least 5 judges or more. Like it means a constitution bench at least have to be made for considering that particular reference. So the answer to the reference, whatever the Supreme Court answers to that particular reference, is not binding upon the President. The President can either accept that or can also reject that. The President has the discretion. He can either accept that particular answer that has been given by the Supreme Court, or he can reject that. But the Supreme Court is duty bound to give that particular answer. And the Supreme Court has to constitute a bench of at least 5 judges. And can anyone tell me what Article 141 says? 141, 141.
So 141 speaks about law declared by Supreme Court to be binding on all the courts.
So it says that whatever law is decided by the Supreme Court, it is binding upon all other courts, including the high courts and all other lower courts like district courts and other subordinate courts. So
it generally deals with the with all the courts which comes under the territory of India.
Yes, yes, okay. So can anyone tell me when the Supreme Court decides a matter under Article 143, that is under the advisory jurisdiction, whether it is binding upon all the courts? It is binding upon all other courts like High Court and the subordinate courts. When a Supreme Court decides a reference made by the President of India, actually it doesn't concern with any other kind of matters or any other appeal or writ petition. It is a reference matter under Article 143, and Supreme Court, a constitutional bench of the Supreme Court, decide a particular point of law. Whether it will be applicable to whether it is binding upon all other lower courts like High Court and other subordinate courts as per the provision of Article 141. Can anyone give me any opinion? Anyone?
Yes, sir. It will be binding.
Yes, sir.
Okay. Yes. So there was some doubt in the minds of some people that it is not binding upon the president, so it will not be binding upon all other courts. But it is wrong. Even if it is not binding upon the president, his high constitutional authority, he has the discretion to reject the view of the Supreme Court. But all other courts have to respect the decisions given by the Supreme Court, especially when it comes from a bench constituted of 5 honorable judges. It is quite important for them to respect the decision made by the constitutional bench. So it is the essence of Article 143. If you go into the details of 143, you will get many other cases. In reference matter, you can find in re as the initials of that particular case. You have heard many cases, you must have heard in re Beruai Union. That is a very important case regarding the preamble. And you must have heard in the special reference number 1, that is the third judge's case that came in the year 1998. So you will find such kind of matters with the initials like in re. In re means in reference. So the president has referred the matter to the Supreme Court. Hence, the decision has been given. So the initials are used in re. So we have covered 143. Now, lastly, I will cover one more constitutional jurisdiction before giving the mic to Debashish to explain the research methodologies. I will deal with the components of the memorial. Then after, I will give Debashish to deal with research methodologies. So one more jurisdiction that I want to explain to you all, that is 139A. Can anyone read it out for me? What Article 139A says?
Sir, it says about the transfer of certain cases.
Yes.
First, where the cases involving the same or substantially the same questions of law are pending before the Supreme Court and one or more high courts, or before 2 or more high courts, and the Supreme Court is satisfied on its own motion or an application made by the Attorney General of India or by a party to any such case that such questions are substantial questions of general importance, the Supreme Court may withdraw the case or cases pending before the High Court or the High Courts and dispose of all the cases itself.
Thanks. Thank you. So it says the transfer of certain cases. So you must be knowing about certain cases. You must be knowing about some news, especially when the Citizenship Amendment Act came. So this particular act was challenged in different high courts. So it was challenged before Delhi High Court. It was challenged before Allahabad High Court. If I'm not wrong, it was also challenged before Guwahati High Court. So all the challenges were made against that particular act. So the Supreme Court has jurisdiction to say that high courts please don't decide that particular matter. Rather, it will be beneficial for the entire population of the country as well as the entire system of the country to transfer that particular matter to me, that the Supreme Court. The Supreme Court can transfer by its suo motu motion. The Supreme Court can say that I will transfer all these relevant matters. The matters should be similar. The cause of action should be similar. And when the cause of action and matters are similar, like one particular act was challenged before different high courts. So when the matter is similar, one particular act, that is Citizenship Amendment Act, was challenged. As the matter was similar, the Supreme Court decided that it will withdraw all the matters pending for all the high courts where the act was challenged, and it will hear the matter, clubbing all the cases together. So it will withdraw the case, the challenge filed against CAA in Delhi High Court. It will also withdraw matter filed before Allahabad High Court. It will also withdraw Guwahati High Court and any other High Court before whom this particular act was challenged. So it will then after club all these matters and will deal exclusively by itself. The Supreme Court will decide that particular point of law by clubbing all these matters, and there is no need to deal with that particular matter individually by different high courts. So it is a very important provision. You will get several moot court propositions where it will be said that these matters are clubbed. But you must know one thing, that it is not a clubbing provision. Many people believe that it is a clubbing provision. It is a mere clubbing provision. It is not so. It is a transfer provision. You have to satisfy some criterions before applying this particular article. As he rightly read it out, there are some criterions where this Supreme Court can withdraw these matters if the matters are similar, if it is before two or more high courts, or it is before Supreme Court and any other high courts, then it can withdraw those matters to itself. These are the criterions. There should be a matter which are similar and either before two or more high courts or before the Supreme Court and other high courts. All these are the criterions that you have to fulfill before applying this particular article. This is not a clubbing provision. You have to transfer those cases before the Supreme Court and then you can club those matters. And this article can be used through three ways. One, the Supreme Court can suo motu, transfer the case to itself. Otherwise, the Attorney General can file an application that Honorable Court, please transfer those matters before yourself, and it will be convenient for everyone. Otherwise, the other party. Other party means any private party who are involved in that particular case, they can also file an application that it should be transferred to the Supreme Court. And it is a rule that whenever a private party applies for the transfer of the particular case to the Supreme Court, he has to file an affidavit with that. He has to file an affidavit. But whenever Supreme Court suo motu transferred that particular case to itself, then there is no concept of affidavit. And whenever the Attorney General, who is the highest law officer of the country, the provision of Attorney General you can find under Article 76. You will read that. Please note it down. You will read that particular provision. And he is the highest constitutional lawyer in our country. So whenever he files an application that the matter should be transferred, he need not file an affidavit with that. There is no need to file an affidavit. So these are the provisions of transfer under Article 139A. So these are the basically most important provisions that you will find about the jurisdiction, the constitutional jurisdiction basically. And except that, you can find criminal jurisdictions under CRPC. There are several appellate provisions under CRPC. You will find appellate provisions from Article 374. You can find 374 Clause 2. That is the most important criminal appellate provision under CRPC, Code of Criminal Procedure. You'll find other criminal appeal provision under 377, and these are the appellate chapters. You can read it out. If you want me to discuss, then I can discuss, but I think we have to go to the components of the memorial, and the provisions are quite evident, and I don't think any explanation is needed on those provisions, so I will not deal with them in detail. The provisions under CRPC, you can read them out. If you have any doubt, you can ask me. I will definitely I will try to deal with those provisions. There are several provisions under CRPC, like appellate provisions. As I said, the most important appellate provision under CRPC is 374 Clause 2. And thereafter, you can have another inherent provision of the High Court, inherent power under Section 482 of the CRPC. So you will read all those provisions. So Debashish, are you trying to say something?
Jyoti Prakash, I think let us do the research methods first, so that they will know whatever components are there to research, and after that we will go to framing of memorials. That will be a step-by-step process, and by that by the time I end, I guess that construction work will also end. So it will be easier for everyone to
Okay,
understand.
yes, that will be
Right.
fine. Am I not audible all this time?
You are audible, but there is a evident background
Yes.
noise, so that is creating irritation. So
Okay.
that might be a problem.
Okay, I apologize for that again. People, please excuse me for that. I cannot do anything. So, do you have any doubt regarding all these provisions that I have discussed about the constitutional provisions under Article 136, 32, 226, 133, 133A, 133, 134, 139A? Anything? 143? Anything? Thank you, Swasti Mr. I'm really happy to know that you understood the concepts. If you have any doubt, anyone, if you have any doubt, please tell me. I will explain. And also tell me if I am going very slow, if I am going very speed. I am going slow because I want you people to understand, to get everything. Thank you, Debashish. Thank you. I want you people to understand each and every bit. If you people want us to hold another session for the remaining part, we will also hold another session. That is quite acceptable. But I don't want any people to go unsatisfied that we skipped something. If you want us to discuss something, then we'll definitely go into the details and we'll make you understand that particular provision. Because we know the intricacies are there, and it is very difficult for the first year and second year students to understand these concepts. Thank you, Vaishnav Priya. I'm quite happy that you people got me. Okay. Do you have any doubt? Otherwise, I will hand over the mic to Debashish. He will explain one of the most interesting and most important part of Moot Court, that is the research methods. He will explain as to how you will get cases, how you will use the databases like SCC, Manupatra, and whenever you don't have any subscription of all those databases, you can also use Indian Canon, that is free database of cases. And from Indian Canon, how you will get authenticated copy of the judgment from Judice, from the Supreme Court website, from High Court websites. Debashish will explain everything. So if you're going there, if you have any doubt, otherwise, if you have any complaint that I was not understandable, or I was slow, I was speed, you can tell me. I will definitely try to improve myself. Okay. So I assume that you people have understood whatever I said. Let's now welcome Debashish to the podium. Please, Debashish, please take over.
All right. So after you people have learned about how to go with your moot problem, and then what are the most probable jurisdictions that can be used by a particular moot problem drafter, and dealing with intricate details of all those jurisdictions, we will now deal with research methodologies. Now, as Jyoti Prakash said, this is the most important aspect of your preparation phase for participating in a particular moot court. So you should listen to this particular segment mindfully, and if you find any doubt in between, you can interrupt me as well. So let's begin with how you should go with your research on a particular moot proposition. So to research effectively for your prospective moot court competition or any other competition, there are a few techniques that I will tell you. And the very first technique that you should adopt is to find out all the relevant textbooks and commentaries relating to the subject of law given in your moot proposition, and read all those relevant provisions concerned. Now, for example, the instant moot proposition deals with constitutional law, the proposition that I have given you. So you can arrange all the commentaries dealing with constitutional law, like D.D. Basu is there, Subhasi Kashyap is there, then MP Jain, V.M. Tripathi, H.M. Sirbhai, Jn Pandey and DJ Day, etc. So there are lots of commentaries which you can use for your initial phase of preparation on a constitutional law moot problem. Likewise, if your moot proposition deals with the Indian Penal Code, then you can refer to Ratan Lal and Dheeraj Lal and Bhubaneswar Nath, then on Basuj on Indian Penal Code, Nelson on Indian Penal Code, etc. So you will find a lot of commentaries on a particular subject of law. So now you can find most of such books in your college library. However, if your library doesn't have these books, then you can contact any advocate for the commentaries from his chamber. Also, there are law schools that give access to their library to students of other law schools. So you can arrange for that as well in any other reputed law college in your area. And again, you can also find Telegram groups, WhatsApp groups, which provide you with a soft copy of commentaries for free. So these are the methods through which you can arrange commentaries and start researching. Someone from you was asking that how you should go with civil cases. So this is the answer. This is a general answer to this. Now, if you are dealing with an intellectual property law case, then you go and find out commentaries dealing with intellectual property law. If you are dealing, if your moot proposition deals with an arbitration case, then go for an commentary on Arbitration Act. And likewise, you will also find a lot of commentaries on civil procedure code as well. So this will be your initial phase of research. You start reading the provisions invoked in your moot proposition and any other corollary provision relating to that, which you think that that particular provision will be important. So after dealing with all these commentaries, after finding out case laws, after finding out all the relevant materials from commentaries, you can move to online research databases. There are many legal research databases which you can use. Now there are free databases and there are some paid databases as well. So before starting that, you should keep in your mind that in real courts or in moot courts as well, you can give judgments from a limited number of databases only. And I will talk about that in the later part of this particular speech or this particular deliberation. Now I will screen share with you and we will go one by one with all the databases that are available with me. And I will tell you certain basic instances as to how to research on those particular databases, which will help you a lot. This is particularly to make you familiar with all the databases and how you can use those databases initially. So let's start with Manupatra. Just give me a second. I will screen share it and I will show it to you. Yes, it's there. Now someone from the attendees, please confirm me that if you can view the whole Manupatra page.
Yes, so it is visible.
All right. So now I will proceed with that. Just a second. Yeah. Now this is the thing that you will see when you log in Manupatra. Now I will tell you the way in which you can access all these websites or you can find relevant judgments for those people who don't have access to this Manupatra SEC online and all. So we will go step by step. Now when you open Manupatra, you will see certain guidelines or certain we can say certain guide to use Manupatra. It is saying that if these icons are there on the judgment that you have found, then the meaning of that particular icon is this and this given in the description part beside that particular icon. As it is saying that if there is blue flag, then blue flag appears against those acts which have been assented to by the President of India, but not yet enforced. It is yet to be enforced. It couldn't be an amendment act or a single parent act. So you can find there are many such description of all the icons which Manupatra generally uses. So you have to go through all these guidelines first. After that, let's go to search. Now here, as I clicked on Manu search, you have to apply the keywords. As I have said previously that you have to find out relevant keywords for finding a particular case. You have to use those keywords here if you are using Manupatra, right? Now, how to use your keywords? There are such certain connectors and certain search operators that you should use while searching through keywords. Now, search operators are symbols or words which can be used to precise your result. They significantly ease the process of searching a particular case. In case you want to find a phrase or a string of words together, then type that particular phrase inside inverted comma. Just a second, I will show you. Now let's search for right to privacy. And we want it to come together. So we have to put it within inverted commas and then click enter. Here. So now you can see in the search result that right to privacy is not scattered. Like right is not somewhere, to is not somewhere else, and privacy is not somewhere else. So this particular connector, this particular search operator, that is inverted comma, has done that this particular phrase or this particular string of words will come in one go. So you can see in search result that everywhere right to privacy is there, it is coming in one string. So that is the use of this your inverted commas. Now, if a particular word that you want that it shouldn't appear in your search results, then you should use a minus symbol. Now, from where I am getting all these things? Just a second. Now, whenever you go to any search database, you will have a certain set of guidelines for that. Now, for Manupatra, you can find out here. It is saying that search tips. Let's click on that. Now you can see under this search tips, it is saying that if you want a normal query, then it has provided a description and an example. Now, if you want a phrase query, then you have to put it within inverted commas, the one that I just have used. Now you can use punctuation connectors as well to omit or add something or want a particular result. And there are many such connectors provided under this search tips. And you will also find these particular connectors, search operators like ending or oring. Now, if you put end between two words, then the search results will give you both the words in your result. If you put or between two words, then the first word may come in the search result or the second word may come in the search result. So likewise, you have to
just we should take a pause for a minute and we can ask people whether they have any doubt, because you have explained many things here. So people, if you have any doubt, like what Debashish has said, what symbol you have to use to make your search more relevant. Do you have any doubt? Please ask Debashish. He will explain again. Anyone? Any doubt do you have? Okay, Debashish, please proceed.
Yeah. So you can find all these search tips in all the databases. This is for Manupatra. So you can do your keyword search here. After that, beside beside this Manu search, there is legal search. This is the most powerful tool of Manupatra, and most probably this particular feature is not provided by any of the legal search databases, even not by SEC Online. SEC Online is very limited, limited to certain reporters only. But in your this legal search, you can find any kind of reporter. That will be under your this citation search. You can see the list of reporters that Manupatra is providing. It's vast, and it is not provided by any other legal search database. So whenever you couldn't find any particular case or citation of that case, then you can use Manupatra. It has listed almost all the law journals or reporters here in this Indian citation. Even it provides for international citations. If you have any international case to cite, you can find it here. UKPC or UKSC, United Kingdom's cases are there, and many such other international reporters are enlisted here. So you can find Indian citation and international citation here. Now again, I was saying about legal search. Now when you should use this legal search feature, when you don't have citation of a particular case and you just have with you the name of appellant or respondent and the name of judge and the case category, suppose writ petition, civil, or it is a Supreme Court case or any other type of case, and you have the date, right? You don't have the citation of that case, then you can use this feature, legal search feature. You can enter appellant, judges, and the date of the judgment, and you that particular judgment will show up in your results. Apart from that, Manupatra has another great feature. Just a second. That is your case law search by case number, right? There will be many cases whose citation you may not find. So if you want to get that particular case, most probably lower court judgments like high court cases or district court cases, then in this particular search option, that is case law search by case number, you can put Supreme Court, any other high court, you can use tribunals. There are a lot of tribunals enlisted here, and the State Consumer Dispute Redressal Commission, you can find international cases here as well, international courts. So after providing the court, whichever court's judgment you are finding, then the relevant case number and the date of the decision. By having all these three details only, you can find a particular case if you don't have a citation with you. Apart from that, you can search acts here, Central Act, State Act, and in any international act you can find from here. Any kind of rules given by the central government or state government, you can find that here. And this is basically the tools that you can use in Manupatra, and that will help you in your research holistically. Now, apart from this, let's go to Manu search. Now there are, I hope that you have understood about Manupatra, how all these things work. Now you have to explore the databases so that you can learn all the intricate options provided by that particular database, because we cannot deal with everything here. I have just told you the basics of how you can use this keyword search here, then legal search for finding cases. Then if you have citation, you can find cases here. And for finding bare acts and all, you can go to that legal search option.
There's so if you have in those filters, the side filters, the Supreme Court, High Court, bare acts, bills.
Just a second.
Yes.
Yes.
Those filters in the left side of your screen.
All right.
Yes.
Now see, after clicking on all these filters, now suppose, wait, you are searching, you search for right to privacy here. and then all the results, all these enlisted results will show up. Now if you want to restrict or filter those results, now suppose you want only the high court orders or high court judgments, then click on this high court only, and you will get only high court judgments relating to right to privacy or any other keyword that you use. Now if you want to check all these things, then it will automatically come up. So in this filters area, you can find your relevant judgment that you were finding, so on a particular topic. So that is the use of these filters basically. So if you want any act dealing with right to privacy, there is no act per se, but if a keyword is related to certain act, suppose an appeal provision under CRPC, then you can find that here under Bare Act section. And if you want any article on a particular subject, then by clicking articles, you can find all those articles on right to privacy or any other keyword, whichever you are searching for. So basically, you should keep in your mind that you can search about cases by getting case numbers. You can search cases by having their citations. You can use a particular database by following the guidelines or tips for that particular database. And after that, if you are searching in a keyword, then you can use such filters, which we say advanced search options, basically, to restrict or to specify or to narrow down your research, because there would be 20,000 judgments if you search a particular keyword, but you want that particular 1 to 10 judgments in your favor. So you have to narrow down your search criteria by using all the features provided in a particular database, whichever you are researching. Now, after dealing with anybody having any doubt on Manupatra? If not, then we will move.
There's just one thing. Please show how to download a case from Manupatra.
Yeah, let's do a citation search for now. Now also, if you can see this, All India reporter have state reporters as well, including that. So if AIR Allahabad is written, it is for Allahabad High Court. If AIR Bombay is written, then it is for Bombay High Court. And by clicking that, you can find Bombay High Court judgments. Now the citation that I have is Supreme Court. So let's move to Supreme Court. You can see AIR Supreme Court. Right. Now we have to enter the year. Now always remember that a citation consists of the publisher in which that particular judgment is published, the year in which that particular judgment was delivered by that particular court, then the volume number of that reporter, and then the exact page number in which that particular judgment has been reported. So these are the 4 basic constituents of a citation, and you should remember these all these things, because there are moot courts where judges ask about the full form of all the ingredients or all the constituents of citations. So if you are citing AIR 1997 Supreme Court 302, then your AIR is the reporter, that is All India reporter. Then 1997 is the year of the judgment. Then SC is the Supreme Court, that is the judgment is given by the Supreme Court. And then 3021, that is the page number. AIR doesn't use volume number. So there are reporters which use volume number. There are reporters which don't use volume number. So you will get all these things after researching citations of various reporters. I will also show you the SCC one on SCC after this. So let's download a judgment from Manupatra. So the year is 1997. After that, AIR doesn't have volume numbers, so we will straight away go to page number. So page number is 3021 here, and the court is Supreme Court. It has taken automatically. Now let's search. Now see, you have found Gaurav Jain versus Union of India and others. This is the case, and the citation is here. Now let's see. Now this is the interface of Manupatra. and you can see the judgment like this. This will come up like this, and this is the particular interface. Now there are a lot of icons you can see on the right hand side of the result. This one is you can print or download the PDF format. This one is you can email this particular page or email this particular judgment. If you want it in Word format, then you can also get it from Manupatra. So these are various icons which you can use for your deep research particularly. Now this print replica thing is that if you click on this, you will get a true copy that has been given by the Supreme Court, or yeah, this is a Supreme Court judgment. So from Supreme Court, let's click on it and you will see that it will provide you the original judgment that has been given by the Supreme Court. Yeah, this you can see judice.nic.in. That is the official website of Supreme Court. So this is a true copy of the judgment. So if you don't want to use Manupatra format or Manupatra's interface, you can simply download it from that print replica and you will get the original true copy of judgment from Judice. So this is the use of this option. Now, if you want to find other citations of this particular case, because a particular Supreme Court case will be reported by a number of reporters, like Supreme Court cases reporter, All India reporter, and if it is a tax matter, then there is tax reporter, and various other reporters are there. So by clicking on this red symbol, which is providing Manupatra's citation, you can find a number of other citation of this particular case. It has been reported by SCC. You can find SCC citation. You can find SCR, Supreme Court reporters here, and then there are a lot of other reporters in which it has been cited. So you can take any one of them for your moot purpose. So this is basically the purpose of your. This is basically the use of the interface of the judgment that comes up. So now to download, you can simply click on PDF and then use with case note or without case note, save PDF to local drive. Now after you submit this particular, that will be saved in the downloads folder or any other local folder that you have assigned. Let's download it for you.
Your screen is not moving actually. I think your cursor is not moving. It is still.
Can you yes, see all the things that I have done?
Still showing AI 1997 SE 3021.
Oh, it didn't show anything that is downloaded.
No.
Can you see another screen that is showing up right now?
No.
All right, that I think I have to do manually. Now it is
yes.
shown, I guess. The part that I have explained regarding the judgment interface, was that shown? Jyoti Prakash?
Yes.
Have you seen the interface one that I have showed?
No.
Just a second.
Yes.
Manupatra is giving different windows, and that is why this Zoom has not selected automatically. Now, just a second, I will share the thing that will see.
Yes, select your entire window, it will show everything.
No, I have selected entire window, but it provides different windows for different searches. So
yes.
You have to do that individually. Now you can see the judgment interface.
Yes.
Yeah, correct. So after clicking the arrow part in the previous window that I have shown you, you will get this particular interface. Now in this print replica, you can find the true copy of the, as I said, true copy of the judgment given by that particular court. In this red underlined citation of Manupatra, if you click on that, you can find all other citations of that particular case. You can find SCC reporter citation, you can find SCR reporter citation, and many such other reporters. So by this way, you can find more than one citation of a particular case. Now, this is a download option of this particular judgment. You can see print document in PDF format. So if you download it, it will be downloaded in a PDF format. After that, you can email this particular judgment to someone. In this, you can download a document copy, Word format of that judgment. And there are many other such icons here, which you can use for your deep research, as I was saying. So this is the particular.
Please tell us what is a true copy of the judgment.
Yeah, now a true copy of a judgment is a judgment uploaded by that particular court, and it has not been edited. It has not been interfered with by any other third-party source. All these Manupatra, SCC, and all are third-party resources, which generally report a particular judgment, and they have their way of citing those judgments in a particular interface. As you can see, this is the interface of Manupatra. But if you see this particular judgment in SCC, the interface will be changed. So now the true copy is the one which you which the court uploads in its website. So that is the true copy one. Now if you wait, I will show it. Now here is this print replica option. I hope everyone can see that. Now if you click on that, you can see true court copy. So on clicking on this particular thing, you can download the true copy of this particular judgment, which has been uploaded by the Supreme Court on its website, right? So is there anybody who has doubt with Manupatra, researching on Manupatra? Anybody? All right, now let's move to SCC. So this is our SCC, and after logging in to SCC, you will see this particular interface of Supreme SCC Online. So here a lot of options are there. You can do word search, as I have said. Now in the word search, the one of the exceptional benefit of searching in SCC is that it has Boolean algorithm feature. By using that, if you are using a phrase of 5-6 letters, then you can use Boolean and you can restrict that search result within a particular amount. Here you can see 10 words range. So if you search 5 words, then it has to be within those 10 words. So this is a great feature of SCC online particularly. Now all those and, not, or and near all these connectors you can use in SCC as well. So always remember that all these connectors which are common, that is in caps and in caps not, in caps or and in caps near, are common for all the databases. So you can use in any database after seeing the guidelines of that particular database. So this is the word search feature of SCC. Now let's
please conduct a demo of those Boolean searches.
Yeah, let's give me wait. Now let's see constitutionality of section, let's say adultery we want to use. Yeah, this is coming. Constitutionality of section 497 IPC. Let's select Boolean and keep it as near 10 words ranges. Now whatever you are getting here, now yeah, in the leftmost side you can see the filters as we have in Manupatra. So you can, if you want to see digest notes only, then you can click on that. If you want to see judgments only, then you can see judgments and all such things. Now we want judgments only, so we will deselect all other filters. Now in the second tab, you will get only judgments which are dealing with constitutionality of 497. Now the leading, all right, let's get acquainted with the interface of SCC. Now in the second, Jyoti Prakash, is it visible?
Yes, yes, visual.
All right. So now see the first one, it is said Somitri Bisnu versus Union of India and the citation of that judgment. In that particular one first search result, you can see it is written J. That means it is a judgment. Then beside that, it is written 3. That means it is a quorum. And can anybody tell me that what is the quorum of a judgment? Anybody from you?
So can I?
Yes, please.
So number of judges in that particular bench.
Correct, absolutely correct. The bench strength of that particular case. So this case was decided by a 3-judge bench or a full bench, as we say. And here you can see 27/5/1985. This is the year. This is the date on which this particular judgment has been delivered by the concerned court. Right. So likewise, you can see all the search results that are providing constitutionality of section 497. And regarding 497, we know that Joseph Sign is the leading case. And it was delivered by 5-judge bench, as you can see. So that is the use of the second tab. Now, in the third tab, that is the biggest one where the judgment is flashing. You can see a lot of options here. Now, this particular option is for copying the citation and party name to clipboard that you can use for putting it on any Word file directly or anywhere else. Now, this one is by using this feature, you will add this particular judgment to your My SCC online folder, which will be kept for you for using file citing that particular case. Now this is case reference, and now this is smart copy. Now if you want to copy a particular paragraph of a judgment flashed by SCC, then you cannot copy simply by using this cursor thing. You have to click on this clipboard that is put behind a particular para. After clicking that, you have to go to here, that is smart copy. Now when you click on smart copy, a window will pop up and that will allow you to copy that down. After that, there is a steering option here. This is the font size. You can adjust the font size of your judgment. Now you can print this particular judgment. Now if you want to download a non-true print with highlight, then you can do that. You can download a true copy as well. If you want non-true print, then you can also do that. There are 3 options. And by clicking on this floppy disk option, you can save that particular judgment. Right. So this is basically the interface of SCC. Now let's move to see another features. Now you can see, as we have explored word search, you can find case law by section. So if you are searching for a particular section, let's say you want to search a particular article of Constitution of India, then select Constitution of India, then select any of the articles of which you want to search case law. Let's say article 21. Let's click on that, and after clicking on that, you will get all the judgments wherein article 21 has been dealt with. Yeah. Now you can see all the judgments. There are almost 15,655 judgments. So to narrow down that, you can do this particular thing. Now if you want to search for right to privacy, this is search within search results option. So to narrow down further your particular search result, and to get a particular judgment, you can use this feature of deep search. Let's search right to privacy. Aadhaar card right to privacy. They are also providing few keywords. Let's search. Now you can see that those 15,655 bulk of judgments is narrowed down to 10 judgments only, wherein this right to privacy has been used. You can see now here you can see the leading case of right to privacy as well. That is KS Puttaswamy versus your Union of India. Now see, or you can find all the judgments wherein right to privacy has been used. So likewise, you can have a deep research and narrow down your bulk result. After that, let's explore this find by citation option. Under this, you can put any reporter that has been enlisted by SCC. You can find SCC, Criminal Law Journal, and AIR, and KLJ, KLT, and many other. The citations are there, reporters are there. Now let's search with SCC. This will be 1997. Now this second space is your volume number. SCC always, SCC citation always uses volume number. So this particular is 8 volume of SCC reporter, and the page number is 114. Let's see. All right. So that Gaurav Jain judgment which we have seen in Manupatra is now flashed by SCC after putting the relevant citation. Now, as I was saying, that interface of all these third-party reporters are different. Now you can very well see that Manupatra's interface was very different from the SCC's interface. SCC provides judgments like in this interface. Now an interesting feature is there in the second tab. See that there is a red symbol. That red symbol is saying that this particular judgment has been overruled. Now if you click on that, at the end of your judgment you will see that it was overruled by same Gaurav Jain versus Union of India in 1998. So this is an interesting feature of SCC, and you can check that if a particular judgment has been overruled by any other judgment. Now apart from that, you can search by party name, by giving the court name and the party name. If you have party name only with you and no other citation, then you can search courts here and then put a party name here, and all the search results will flash here, wherein those names, that particular name has been used in a particular case. Let's do that for you. Let's say Supreme Court. Let's say Joseph Sign. See, it is coming. Now when you search find case, you will get 6 results. There are 6 cases in the name of Joseph Sign. So whichever case you want to find, you want to get, you can click on that simply and you will get the judgment. Now that is the SCC feature for you. Now if anybody has any question related to this, they can put forward.
Debashish, we have received a question on WhatsApp group. Please look into that. It's Krishna Chandra Dora is asking that if there is any other string search. Now see, the string search is, as I said, can be done by inverted commas or our circular bracket. That depends on that particular search engine.
Now, in most of the search engines, your inverted comma can be used for getting a particular phrase in a string, and it will come in one go and it will not be scattered anywhere. So all these things are there. Now you can, if you Google that, what are the connectors or what are the special operators, search operators are there for efficiently researching, you will get a lot of operators for that. So you have to use all of them, and subsequently you will get acquainted with that search format so that you can search it later on efficiently. Now, if I don't have a habit of using those inverted commas, then obviously I won't search like that. But the person who is having the habit of using those inverted commas, he will use that and he will get specific results. So all these special operators, search operators and connectors help you precise your result. So you have to learn those things from the guide of that particular the research database. So as now we have seen SCC and Manupatra, we will now deal with those websites which can be handy and which can be very useful for those law students who don't have access to Manupatra and SCC, which are paid websites. Now, the most relevant website that you can use for downloading the judgments is your sci.gov.in. Now here, Jyoti Prakash, is sci.gov.in showing?
Yes.
All right.
Yes, before going to that, there is this Sahil Sumandir has written that he has not understood something. Please check the chat box.
Chat. As I am sharing, I cannot use the chat box.
Okay, I'm telling you.
Please read that.
He's saying that I didn't get how to narrow down judgments, probably in SCC.
Yeah, see, as I just said that after flashing off your results, as I just said, you can see SCC now. You can narrow down your results by this. Here you can see a tab is there, search within search results. So after putting your keywords there, that will narrow down your result to those judgments, limited to those judgments only which has that particular keyword. As I have shown you that there were 15,600 something judgment on right to personal liberty and right to life under Article 21. But when I put right to privacy in this search within search results, it narrowed down to 10 judgments only from 15,000 judgments. So that is how you have to use the advanced feature of all these databases, and you can narrow down your judgments. You can basically learn all these things after exploring those databases personally. I am just giving you the basic approach towards all these databases and how you can learn to use these particular databases per se in a basic manner, or in an we can say in a new manner, infant manner basically. So you have to explore all these things to master all these databases. Now, as I was saying that there is a website from where you can download judgments for free. Now, if you want to download a Supreme Court judgment, here a lot of options are there. Among them, you have to click judgments. Now, after clicking on judgment, if you have found that particular judgment, then you can simply use the case number feature. Now, in the case number feature, there are a lot of nomenclatures, case types basically, which you can use. Now, if your case is a specially petition civil, then you will use specially petition civil and the case number and the year of that particular judgment, and then put the captcha. Let's try for one judgment. Kesavananda Bharti versus State of Kerala. It will come in Indian Kanun. Now from here, you will get the case number. This is writ petition civil. Case number is 135 of 1970. Now after getting that, we will put it in Supreme Court's website. Writ petition civil. Case number is 135 of 1970.
I think that will not work because you have selected read to petition. Read petition.
All right. Sorry. Here is writ petition civil. 135 of 1970. Your 135. Now you have to select the year, that is 1970, and then you have to enter a captcha 9859 and then submit. Now you can see that the Supreme Court's website has flashed Kesavananda Bharati's judgment. Now on clicking on the date here, you can download the judgment. Now you, as we were discussing about true copy, this judgment will be the true copy of this particular case because it has been directly uploaded by the Supreme Court on its website. Now if you will be looking for any High Court judgment, then you can find in a similar fashion all the cases that has been uploaded by a particular High Court. So this is the way you can download free true copy of the cases that you have already found and you want to cite those judgments before a particular court. And this is very well acceptable. There is a misconception that if you download a case from SCC only or Manupatra only, then that is acceptable by a court. No, that is not the thing. The first and the uppermost level in the hierarchy of providing the services of judgments is this your sci.gov.in. That is the own website of Supreme Court. So if you download a judgment from here and you give it in a court, then that will be very well acceptable above any judgment downloaded from SCC or Manupatra. So please remember that. There is a misconception that you cannot give judgment from sci.gov.in, but that is not true. Now there is another tool, that is Indian Canon, which is absolutely free, and that comes handy for our law students who are in traditional law colleges and who don't have access to this SCC and Manupatra. Now also, as I was saying, you can get SCC and Manupatra from after contacting any advocate who has these legal database resources in his chamber. If your college doesn't provide for that. Now in Indian Canon, which is absolutely free, you can search by using all those connectors and search operators that I have said before starting this particular topic. Here also you can see there are certain guidelines. After clicking on search tips, you can see it has a number of paragraphs which provide that you can search like this. Now you can see operators. You can use AND operator, OR operator, NOT operator, and all those things to search in your Indian Canon. Now let's use our that phrase operator, that is inverted comma, and find right to privacy. Let's search that and let's see what happens. Yeah, see. You will find all the judgments here concerning dealing with right to privacy. This is the interface of Indian Canon. Now on the left side, like all other databases that we have discussed, there are many filters. You can restrict to High Court judgments. You can restrict to Supreme Court judgments here. If you want Delhi High Court judgment, which is dealing with right to privacy, then you can click on that and it will restrict it. Now see how you have narrowed down your research from 2000 judgments to only 163 judgments given by Delhi High Court. You can see only Delhi High Court judgments in the search result. Now, if you want to further narrow down this, then there is again a feature that is search within results. That that is quite similar to the feature that we have discussed while discussing SCC. So let's search for gender identity and see what happens. Now see, again you have narrowed down 163 judgments to your 7 judgments only, which are dealing with right to privacy and gender identity, and which are Delhi High Court judgments, right? And this is the way you can search your judgments on Indian Canon for free. That is absolutely free. You can also use advanced search feature. Also, please remember that advanced search feature is there in each and every platform. And if you are not acquainted with all these search operators and your connectors, you can use this advanced search feature and you will get all the relevant case laws that you are searching for. And again, there is Hen Online website, which is generally used for researching your papers or the journals. Now let's see how Hen Online works. Now most of the law colleges don't provide for Hen Online, but if you have Hen Online, then you can take tips from here. Now in similar fashion, let's search right to privacy without any your connector or search operator. You can see in the search result that right to privacy is quite scattered in the search results. But if you use those inverted comma search operator, you will see that it will come in a string. And it won't be scattered like this. You can see right. You can see now right to privacy. Right to privacy. It is coming in one string and not scattered, like the way we have seen previously. So that is how you can use all these connectors on various legal search databases. You can use filters to narrow down. You can use search within the documents. Here you can see sort by relevancy is there, and here refine your search with all these features on Hen Online and all that. So basic thing is that you have to read the guides or tips given by those databases, and after that only you can use the data, that particular database efficiently, and by trial and hit method, and after applying all the connectors, and after knowing that if you apply a particular connector what happens, after knowing all these things with due experience, with due research experience, you will be an experienced researcher on all these platforms. So I hope I have made it very, very clear as to how you should use all the most used databases like SCC, Manupatra, Hen Online, and sci.gov.in, and of course Indian Kanun, which is free for students like me and Jyoti Prakash who are hailing from traditional law universities. If you people have any question, then you can tell me. You can ask me. As Jyoti Prakash said, we are in a holistic discussion and you can ask anything related to the topic that has been just discussed now.
So can I?
Yes, please.
So in case we don't have SCC online or Manupatra subscription, then it's completely okay to stick to Indian Kanun, right?
Now see, there is a trick on that. Supreme Court has given an order recently, or a notification, which we can say, stating that from which websites the judgments are acceptable before the Supreme Court. So we generally follow that format for our moot courts as well. It has provided that the judgments downloaded from its own website, that is sci.gov.in, as I just said, is acceptable. If you download a judgment from SCC online, that is acceptable. And if you get a judgment from Live Law or Bar and Bench, who both these websites generally give a true copy. They don't do any editing, or they don't publish their own interface judgment. So they just put the true copy of the judgment. If you have explored Live Law and Bar and Bench, then you would be knowing that. So that is basically downloading a judgment from sci.gov.in, that is true copy judgments. So both these websites are only acceptable before the Supreme Court. Now, if you are appearing in a moot court or trial advocacy competition, it is always advisable that you download the judgment from either sci.gov.in or from SEC online. They are not accepting Manupatra even for certain reasons. So if you give Manupatra and if that judgment is quite correct, then that will be acceptable. But it is advisable to avoid Manupatra. You can use that for researching and finding judgments. But when you submit your compendium, when you submit cases, you stick to sci.gov.in or this SEC online. I hope Debashish, I have made this point clear.
Yes, sir. Yes, sir. Thank you, sir.
All right. Any other questions?
So this is, let's take a test. Let's tell people to volunteer and search a case from Indian Canon and get the judgment from sci.gov.in. Anyone who wants to volunteer for that? Anyone who can share his or her screen? Yes.
We are not telling you to find a judgment on particular proposition of law.
Yes.
Just repeat the Kesavananda Bharti thing.
Yes, that will be okay as well.
We will be happy that we have sufficed the purpose of holding this workshop.
Yes.
That now you know how to get cases. Any one of you?
Yes, you can share your screen. Just clear your tabs if you have anything personal. You can share your screen, and then you can. We will give you a judgment. You have to search that on Indian Canon. You have to get the case number, and then using that case number, you have to find out the judgment from sci.gov.in. Can anyone do that? This is very clearly explained each and every bit. So I think you people can do that. Anyone can volunteer for that. Anyone? Divyasri, do you want to volunteer for that?
I will guide you in the process of that. It's not that we will be awarding you 100 marks if you cite that correctly, if you find out that correctly.
Yes.
We will guide again step by step. So if anyone can do that for us.
Sir, can I volunteer?
Yes, please. We will be glad.
Okay, sir. I may have some noise problem because my brother is studying beside me. So please excuse me for that.
Not an issue. Not an issue.
Okay, sir. Can I start right now?
Yes, yes.
Yes, sir. I'm sharing my screen.
All right.
Sir, is it visible?
Not now, I guess.
Sir, here it is showing only the host can share in this meeting.
All right, all right. Just give me a second. I will give you the permission. Now you can try. I have given you permission.
Okay, sir. So now is it visible?
Yes, we can see your mobile interface. Yeah.
Sir, on what platform should I use it?
Google, that we generally use.
No, sir, not that. I mean, Indian Canon or SCI or.
While starting researching, you simply type the case name in Google, and automatically it will redirect you to. Automatically, it will show Indian Canon's result.
Okay, sir.
And various other results.
So
Now
which one should I, sir? Keshav Nanda Bharti.
Bharti, yeah.
No, let's try something different. And now search K.S. Puttaswamy versus Union of India.
So once again.
K.S. Puttaswamy, K.S. Puttaswamy, P-U-T-T-A. Yeah, yes. It is coming. K.S. Puttaswamy versus Union of India. Click on that. Yeah. Now see, the first one is only Indian Canon. Click on that.
Yes, sir.
And if you don't see any Indian Canon option while searching this, then you can write Indian Canon after the case name, like case Puttaswamy versus Union of India, and
Keyword
beside,
Indian Canon.
yes, Indian Canon. Beside that, you can write just Indian
Yes.
Canon. So, yes.
Now scroll down a bit.
Yes, sir.
Yeah, now see, you can see the case number. That is writ petition civil number 494 of 212. So now you have got case Puttaswamy's case number and the type of case. Now you
Yes,
go
sir.
to sci.gov.in.
You can open a different tab as well. You can keep that page open. Yes, yeah.
sci.gov.in. gov.in. Hold on for a second. It will take time to load, I guess.
Yes, sir.
Yes. Now on these three lines, which you can see.
No,
Yes,
no, no. Case information. Case information. Tap on the case information. Click here.
Case information, sir.
All right. This is the first gray tab one.
Yes, the black one. Case information bracket. Click here.
So where is case information? Oh, here.
Just below Supreme Court of India.
Yes, sir, I
Yeah.
got it.
Select judgment. Yes. Select judgments.
Yes, sir.
Now enter the particulars that we have obtained from Indian Canon. Writ petition
Sir,
civil.
can I look
Yes,
at
yes,
one
yes,
second?
yes, yes.
Petition civil.
No, that is civil appeal.
Civil appeal.
Oh, yes, sir. Civil original jurisdiction.
Yes, yes, yes.
No, you have to click on this writ petition civil. That was scroll above, scroll above. Not down, scroll above. It was on 5th or 6th tab.
Yes, sir. Writ petition
No,
civil.
no, it
No,
is
writ
petition.
to petition. This is a different acronym. There is writ petition civil. Just scroll above, scroll above, scroll above. Yeah, this one, writ petition civil. You can see below criminal appeal.
Yes, sir. I just saw it.
Yeah. Now you enter the case number and the year of the case.
Case number 494.
.494 and then choose the year. That is 2012. And then add the captcha. No. You have to add the captcha before. That is your 2223.
Sir, is this captcha thing is only with sci.gov.in or is it with every other site like Manupatra or?
No, not on Manupatra and SCC.
Okay, sir.
Yeah. And now you can see the red dates.
Yes, sir.
That is in the yeah. You can click on that. And you can check that it would have been downloaded.
Yes, sir. It's showing.
Right.
Yes, sir. It's been downloaded.
Now open that and you will see you have downloaded a case Puttaswamy. True copy of judgment. Yeah, this is the true copy.
Yes, sir.
So this is the way.
It is coincidentally the longest judgment the Indian court
Can I
ever
stop
delivered.
sharing my screen? Is it okay?
Yes. All right.
Thank you, sir.
Thank you. Thank you for
Did
taking
everyone
the
understand?
effort.
Thank you, sir, for guiding and all.
Please tell us, everyone, all the 11 members who are present here, that if you all have understood, you can type yes in the chat box.
Yes.
All right. I think Jyoti Prakash, you can take the mic and discuss components of memorial now.
Yes. So there is should we discuss today? I can see many participants have already left the meeting. I think it is causing some hardship for all the participants. Should we continue today? the participants who are present here, kindly tell us if we should continue today or whether do you have any other assignment or any other work. Then we can also resume it tomorrow. If you say that we can resume it in the morning hour for 1 hour or 2, because we are going to deal with another important section that will take an hour or 2, I think. Just tell me in the chat box. Should I continue here? Okay. Today is fine. Okay. Fine. Then I will continue. Okay. Thank you. So I'm sharing my screen. I will show you a sample of Moot memorial, and that Moot memorial has been also shared with you, but I will show you another memorial that is similar. I will show you my memorial. Another memorial has been shared with you people. I am sharing my screen and I will explain each and every part of the memorial. Okay. Is it visible, Debashish?
Yes.
Okay. The memorial is showing, right?
Yes, memorial is fine.
Okay. You can see I got a request that I should continue tomorrow, but majority opinion is I should continue today. So I am continuing today. If some people have some hardship, then they can leave. But it is most desirably advised that you people please stay here. Please learn here. You can also question me each and every part. But if there is any urgency, you can leave now, and it is recorded in the YouTube. You can also see that. But please remain here if you can. Okay. So I'm going to discuss the details of the Moot memorial. So it is the cover page. It is the first phase of a Moot memorial. Whenever you will try to draft a Moot memorial, you will start with cover page like this. So can anyone say why the first page of this Moot memorial has been colored as red? Can anyone tell me? Anyone? Can anyone tell me why the cover page is colored as red in this particular memorial?
Because in moot court competitions, we generally have the rule of coloring the respondent's side using red. The front should be in red color.
Yes, right. So in moot court competitions, especially at the national level, also in the regional level, you people will get an instruction from the organizing committee that you have to color the cover page of the petitioner or appellant in blue, and the cover page of the respondent or the opposite party red. So as I am showing you a respondent side memorial, so it is showing red color. It is the cover page, and I had to color it as red. So first thing that you can see here, it is team code. So what is the purpose of a team code? So whenever you will participate in a national moot court competition, especially in the national moot court competition, you'll definitely get a team code, because it is assigned to each and every team to hide your identity, because it is not desirable to expose your identity, because there is every chance that some people will be there who will be knowing you, and they will involve in some biased activities. So it is always advised that you will not disclose your name nor your institution name. You have to get yourself identified by team code. Here I have got the team code LS02. So my identity throughout that competition will be LS02. Okay. Whenever you will participate in a national moot court competition, even if someone asks you as to what is your college name and what is your name, please don't disclose. It is a rule, and if you disclose, then it will also lead to your disqualification. It is upon the discretion of the organizing committee. If they find that you have disclosed your identity, and after doing that you have got some benefit by using your identity, then it can also lead to your disqualification from that particular competition. So it is always desirable that you will hide your identity and use team code for your identification. Okay. So I have got the team code LS02. So I have written it here. So my identity for that particular competition is LS02. And this particular identity will only be revealed after the completion of the competition. If I get some position, then it will be declared as LS02 has won the competition, and they belong from University Law College, Utkal University. So it is the rule. And the second line, you can see legal spectrum Moot Court Competition 2020. Especially in Moot Court competitions, after team code, you have to mention the competition name. Because it becomes very precise to find out as to in which competition you are participating in. So it will be definitely helpful for all the judges, especially for those judges who are judging in different Moot Court competitions simultaneously. They can easily know as to in which competition you are participating in. So it is always desirable that you use this particular line as to in which competition you are participating. If you are participating in this particular National Moot Court competition, please mention the name. After that, you can see I have written in the Honorable Supreme Court of India. It means the third line should be as to in which forum you are appearing in. I was appearing in Supreme Court of India. So I have written that in the Honorable Supreme Court of India. Otherwise, I could have also written that before the Honorable Supreme Court of India. That means the same. Okay. It is the forum name. You can note it down if you want to note down the details, the components of a moot memorial. Then you can also note it down. First thing you have to write team code, then competition name, then the forum in which you are appearing. Okay. So then this line I have written under Article 142 of the Constitution of India. So 142 is another kind of jurisdiction. It is the jurisdiction is a special jurisdiction. The Supreme Court under Article 142 has power to do complete justice, invoking its external jurisdiction. So I had tried to invoke that particular jurisdiction in this particular case. So in this line, I want to say that under which provision I got the right to approach you for this honorable court in this particular case. If it would have been a writ petition, then I would have used Article 32. If it had been a special petition, then I would have used Article 136. So you have to use in which provision, under which provision you have got the right to appear before an honorable court. Okay. Then this is the case type. Just now, Debashish has explained as to how you will get a particular judgment using the case number. So it is the case type. It was a transfer case. So it was the case type. And always remember, the case type keeps on changing from court to court. Means in Odisha, if you are approaching the High Court under Article 226, it can be said as you are appearing under the writ petition bracket civil. Under the case will be categorized under writ petition civil. If you do the same in Bihar, in Patna High Court, it will be written as civil writ jurisdiction, CWJ. Here WPC, there you can find CWJ. So no matter how it is named in different courts, the essence is the same. If you are using the writ jurisdiction, then you have to write the writ jurisdiction you are using. And in this particular case, my case was of transfer type. So I used transfer case number. Here I gave a dash because I was not assigned any particular case number. In a Moot Court competition, you are hardly ever assigned a particular number of your case. So I have put a dash. If I would have been assigned a particular case number, I would have put the case number here. And by 2019 means it is the case of 2019. Okay. After that, I have to write the case name in the matter of Mr. Saxena and Vasu. Those are the petitioners versus Messrs. Waste Business Solutions and another versus respondents. Can anyone tell me why I have used the word another here? Can anyone tell me?
Because there is one more party.
One more
Okay.
party or corporation.
Yes, right. If I use in the place of ANR, if I use ORS, what does it mean?
Others.
Why I
More than one
use?
parties.
Yes. What is the difference between using another and others?
So in one party, many
Yes.
people are there, others. And if another 2-3 groups we are telling them another, like
Yes.
one group.
Okay, okay. Yes, yes. Right. So when I use another ANR, the short form is ANR, it means except best business solutions, I have another person or another party, another person or another legal individual. For example, I have, no, sorry, I have two parties in the respondent side. So I have used another. If there are more than two persons in the respondent side, then I can use others, because except the first respondent, I have more than one person, then I can use others. If except the main respondent or main petitioner, whatever the case may be, I have just only another person, then I can use another. Otherwise, if there are multiple persons, I can use others. Okay. So in this format, you have to write your case name, whatever it is, you have to write. Yeah, petitioner versus respondent in this type, and then you have to go on to define as to for whom you are appearing. I have written that memorandum filed on behalf of the respondents, means I am appearing on behalf of the respondents. I am appearing for the opposite party here. In this particular case, I was amicus curiae. Actually, amicus curiae doesn't appear on behalf of anybody. So just excuse me for using this word. This word was particular for that particular moot court competition. In the place of amicus curiae, you can assume that I have written here the parties or the councils. The councils are appearing on behalf of the respondents. Don't treat it as amicus curiae. In the place of amicus curiae, assume that I have written councils appearing on behalf of the respondents. Okay. So you have to define as to for whom you are appearing. And after that, you have to write upon humble submissions before the Honorable Chief Justice of the India and His Lordship's companion justices of the Honorable Supreme Court of India. So by that, I mean that I am addressing this petition to the head of the judiciary. As I am appearing on behalf of, as I am appearing before the Supreme Court of India, then I have to address this to the head of the Supreme Court, is the Chief Justice of India. And after that, he can also assign that particular matter to any of his companion justices. So I have written to the Chief Justice of India and his companion justices, his Lordship's companion justices. It is the discretion of the Chief Justice of India. If he wants to deal with that particular matter individually or by himself, then he can deal with that. Otherwise, he can also assign that particular case to any other bench as he may deem fit, because he is the master of the roster. He decides as to which judge hears which case. So I have written that I am addressing to the Chief Justice of India. Okay. So we have covered the cover page. Do you have any doubt as to what we should write in a cover page? You can ask me if you have any doubt.
So what if it is a case of criminal law case?
Mm-hmm.
Then under their articles, so we can't write, we will write section.
Yes.
Like in the humble Supreme Court will not write, because in a moot proposition it is High Court. Then under articles we won't write, we will write under section.
Yes, sections. Yes. In a criminal case, if you are appearing on behalf of a party in the High Court, for example, you are appearing in a criminal appeal before a particular High Court. For example, I am appearing in the Odisha High Court, so I will write in the Honorable High Court of Odisha under Article 374, under Section 374 Clause 2 of the Code of Criminal Procedure 1973. Instead of Article 142, because it is a constitutional matter, so I have used article. If you are approaching to the Honorable High Court or any other court for a criminal matter, and you are approaching under a criminal jurisdiction that is provided under the Code of Criminal Procedure, then you have to write under which provision, which particular provision. So it is not a definite provision. You can use that according to your facts of the case. Under my facts of the case, I had to use Article 142. If your case is of a criminal nature or a civil nature, you have to accordingly change this particular line. All these lines have to be accordingly changed. So you can write sections as well. You can write also the name of the statute which prescribes that you can appeal to the Honorable High Court under that particular provision. Okay. So you have to accordingly change the case type as well. If you are appearing in a criminal case or a criminal appeal, you have to write criminal appeal number dash by the year name. Okay. In the matter of, you have to write if the accused has challenged the conviction by the trial court. For example, you take Mr. X has murdered someone, and the trial court has convicted him and punished him with death penalty. He has appealed to the High Court. Then you can write Mr. X, he will be the appellant because he has appealed his conviction. Then you can write Mr. X, that is appellant. In the place of petitioner, you can write appellant because who appeals is the appellant. Who petitions is the petitioner. If you are filing a writ petition or any other kind of petition, then you will be known as petitioner. If you are filing an appeal, then you will be known as appellant. And if you are filing a suit, then what you are called as plaintiff. Okay, you have to know these basics, basic terminologies. So in a criminal case, you have to write the example that I gave. Mr. X has murdered and he was convicted by the trial court, and he is now appearing in the High Court against the conviction. You can write Mr. X, that is the appellant, under the relevant provision. That is 374 clause 2 of the CRPC. So Mr. X, that is appellant, versus in a criminal case, you have to remember that always in a criminal case, the state is a party. Because the criminal offenses are against the state as a whole. It is regarded that the criminal offenses are not only confined to individuals, but it is against the state as a whole. So in all the criminal cases, except a few, in some defamation cases under section 499, you will sometimes find that there may not be a state. But except that, in every kind of criminal cases, the state is a necessary party. So you have to definitely add state as the respondent if you are appealing against a conviction. So in a criminal matter, you have to add state as a party. You have to write this. So if you get a proposition and a criminal law, always remember, add state as a party. And by state, I mean state under Article 12 of the Constitution of India, not this particular state of Odisha, state of Jammu Kashmir, state of Chhattisgarh, not these kind of states. By state, I mean the state that is defined under Article 12. And what Article 12 defines, you have to read. If I go on to describe what Article 12 reads, then we will not be able to cover all these concepts. Okay. So in a criminal case, you have to add state as a party. Accordingly, in a civil case, it will be between two individuals. If it is between Mr. X and Mr. Y in a partition suit or in a civil dispute, you can write Mr. X as petitioner, plaintiff, versus Mr. Y as defendant. In a civil case, you will find plaintiff and defendant. In a criminal case, you will find prosecution. In a lower court, you can find prosecution versus prosecution versus accused. If it is appealed by the accused, if the conviction is appealed in the upper court, then it will be the accused will be called as appellant and the state will be called as respondent. And in the constitutional case of this type, in writ petitions, in special lay petitions, and in other kind of constitutional cases, you will find petitioner and respondents. Okay. Do you have any doubt?
Thank you, sir. Thank you so much.
Any other people? Do you have any doubt?
Yes, I had a query.
Yes.
Yes. If the facts of the moot proposition is such that there are more than one petition that are to be listed together for hearing. if one petition is A versus B and other petition is B versus A, so
Yes.
we on the petitioner side and
I got your point. Thank you. Okay. So she is actually asking us if the cases are clubbed together or tagged together, how we will write that. So here my matter was a singular matter. There was no other matter except this matter. So I have written this party versus this party. But for example, you take another matter has been tagged with this matter for hearing. Especially in the matter of death penalty, you can get two matters. You will get always that two matters are tagged together. Okay. It is very usual. You will find that accused has appealed against his conviction and death penalty, and state will go for the confirmation of that particular death penalty, because death penalty is not so much confirmed. It should be confirmed by a division bench of the High Court. If the trial court gives you death penalty, it is a procedure under CRPC. You can read section 366. It is a procedure under CRPC that whenever a death penalty is imposed, the High Court should confirm that particular death penalty, and it should be consisting of two judges, at least two judges. The bench should consist of two judges, like it should be a division bench. So in a death penalty case, you can find that accused will appeal against his conviction and will go to the High Court. At the same time, the state will go for confirmation of that particular death penalty. So in those matters, the two things are tagged. Like the appeal of the accused, it will be called as accused versus state with. When matters are clubbed, after this line, you have to give a space and write. You have to write with, WITH with, or you can also write tagged with or clubbed with. Then you can write the cause title of the second case. This is called as the cause title. This part is called as the cause title. Means party 1 versus party 2 is called as the cause title. So in a case, as he said, when you will find two cases are tagged together, you have to write those cases with a conjunction that will be called as clubbed together or tagged together or with. Simply you can write with. It means two matters are tagged. After this line, you have to give a space. Under this line, you have to write with. Then you can write the second matter. It means two matters are tagged together. Okay. I think that clarifies your doubt.
Okay, there is a follow-up question also, like
yes,
point of clubbing and the way we need to write the cause title. But again, question was like from petitioner's side, I'm not talking about the real situation, because in real situation we get to like file for the accused and for the state we can file separately. But now since we are talking about moot proposition and moot court, so petitioner side, like whose side should I present? Should I present from accused side or for the state side? Because in one petition, accused is the petitioner, and in other like petition, state is.
Got your point. Okay. So in those cases, you have to follow the instruction of your organizer. If your organizer is saying that you have to consider the first petitioner or the first appellant as the appellant for every cases, then you have to consider him as the appellant. It means in the first matter, for example, you can take in this particular matter, Mrs. Saxena and Vasu are the petitioner, and Mrs. Best Solutions and another are the respondents. But if another case is filed where Best Solutions comes to the position of petitioner and Saxena and Vasu comes to the position of respondent, then you have to consider the position of the first case. It is the first case, and the second case will be after the tagged with, after the word tagged with. So usually in a moot court competition, you have to follow the position of the parties which has been provided in the first case. In the first case, Mrs. Saxena and Vasu are the petitioners. So it is usually done that I have to consider Mrs. Saxena and Vasu as the petitioner for the entire case, notwithstanding with the fact that in the next case or in the tagged case, they are the respondents. Did you get it?
Yes, thank you.
Okay, thank you. So do anyone has any doubt? Does anyone has any doubt? Sorry. Okay. People, please feel free to ask me anything. If you have anything or you are stuck with anything, please ask me. I'll try to clarify. Anyone? Okay. So I assume that you have understood the components of the cover page. I will say the synopsis of the cover page. You have to first write the team code. This is the team code in a box. Then you have to write the competition name, then the forum, then the provision under which you have proposed the underable code at the forum, then the case type and number, then your cost title. No matter whether you have one cost title or two cost title or multiple cost titles, you can write that by using the conjunction called with, or you can also write as tagged with or clubbed with. Okay. After that, you have to specify as to for whom you are appearing. Then you have to make an humble submission before the honorable court that you are submitting this petition for their consideration. Okay. These are the basic components of a cover page. Okay. Then we come to development.
Sorry, Jyoti Prakash. There
Yes.
is a question in the chat box.
Yes, yes.
Please refer to that.
I cannot see. Please read it out.
Yeah, the question says that what jurisdiction should be written on the cover page in case of tagged cases?
Okay. In a tagged case, like I said, in this, if you take the example of death penalty, in a death penalty, you will find that the accused will go an appeal against his conviction under section 374 clause 2. Okay, because that is the provision which provides him a right to appeal against his conviction and sentence. And at the same time, state will go for the confirmation of the sentence. Okay, so the state will go under section 366 of the CRPC. Okay, so you have to write, if the cases are tagged, you have to write under section 374 clause 2 and section 366 of the Code of Criminal Procedure 1973. Or in other case, if I take another example, if two writ petitions are clubbed, here, for example, take this is the writ petition and another writ petition, similar kind of writ petition, two writ petitions. As I had already said, for example, you can take CAA. Those cases are clubbed together. So constitutional validity of CAA was challenged, and those were challenged under the writ jurisdiction of the court. So those are especially under 226 in the High Court. So when those matters are transferred to the Supreme Court, then those are the writ petitions. Then the Supreme Court can write the writ jurisdictions. Like it can write under Article 32. Okay. If multiple writ petitions are tagged together, you can simply write under Article 32. There is no need to write 32 and Article 32. If two matters are tagged, you should not write Article 32 and 32. This is one method. If you want to specify the jurisdiction under which in a particular case you are appearing, or in a particular cost title you are appearing, then you can also write the jurisdiction right here, just below the cost title. You can put a bracket here. You can specify as to in which in this particular cost title you are appearing under this particular article or particular section. And then you can write tagged with or with, then write the another cost title. Then under that particular cost title, you can also write under which particular provision you are appearing. You have two options. You can write either all the jurisdiction clauses or the jurisdiction provisions right here. Otherwise, you can write the jurisdictions under the particular cost titles. Is that clear? The one who was asking, is it clear to you? Am I audible, Debashish?
Yes, yes. Yeah, her doubt is clarified now.
Okay. So the basic thing is you have to specify your jurisdiction. So you can do that here, right here. If the cases are of different types but similar, then you have to specify the jurisdictions. Like I have said, in a criminal appeal and in a death reference, you can write section 366 and section 374 clause 2. You can write here, right here. Otherwise, you can write just below the cause title. You can specify as to in a particular cause title in which jurisdiction you are appearing. So you have two methods. You can follow either of them. So next we come to the table of contents. So you can see these are the basic components of a moot memorial. You can see first is list of abbreviations. So whatever abbreviations you will be using in a moot memorial, you have to enlist all those abbreviations under the list of abbreviations. I can show you the list of abbreviations here. Yes, you can see. You can create this kind of table. Otherwise, you can also write all these abbreviations without using a table. It is on your discretion. Whatever you find fit, you can either use a table. Otherwise, you can simply write the abbreviations using some symbols. Okay. So whatever abbreviations I have used throughout the memorial, I have to enlist all those abbreviations here. What is the purpose of enlisting all those abbreviations? Because in a real court, even in a moot court, if you are using some abbreviations in the argument part of your memorial, and the judges is going through that, and he doesn't understand actually what you are trying to convey. If I have written in the argument, for example, EULA, and the judge doesn't understand what EULA actually means. It is a technical term. So this means end user license agreement. So whenever judge or the other party finds some difficulty to know as to what you want to say, then they can directly refer to the list of abbreviations and they can get the extended forms of all those abbreviations. So it becomes easier for them. So that's why whatever abbreviations I am using, whether it is a reporter name, whether it is some technical names or FIR, anything, even the para symbol, you should extensively write the extended names so that it will not cause difficulty to the people who are going through it. Okay. So this is the purpose of list of abbreviations. You have to enlist all the abbreviations in a tabular format or simply. Okay. So after that, the next section is index of authorities. It is one of the most important sections. Okay. A table of contents means the contents of the moot memorial. Whatever contents you have written in a moot memorial, you have to enlist the page number and that particular component here. So it is the table of contents. It is just like your table of index or table of contents in a book, in a hard copy of your book. You can see you will get an index. You will get an index. So it is like that only. It is just a reference for your convenience. This particular section has been enlisted in the page number X. So it is for your convenience. You can get the page number very easily from the table of contents. Okay. So next we go to index of authorities. Let's see. Okay. Here's my index of authorities. Okay. Here I usually cite more cases. There are many tendencies between different people. Among different people, they use other kind of authorities as well, like articles, other online sources. But I usually prefer to use more case laws than any other kind of authorities. So I have enlisted all the cases that I have used in this particular memorial. I have written serial number of the case. You can see 1, 2, 3, 4. Case name. It is alphabetically arranged. You can see here. It is alphabetically arranged. Then case citation. What is the citation of that particular case? And then page number. Page number means in which phase of this memorial I have used that particular case. This is most important section. Many people tend to omit this particular section. They don't enlist in which phase they have used that particular case. That is a wrong method. You have to write as to in which particular phase you have used that particular case, because that shows your authenticity. Otherwise, the judge will assume that you have not used that particular case, but to lengthen your reference section or the index of authority section, you have written down that particular case. So it is always advisable, whatever case you are actually referring in the argument advance section, you will enlist those cases here with citation, with page number, with serial number, and alphabetically. Okay. So these are the cases that I had used in my moot court. So these are the cases I have alphabetically arranged them, and in a tabular format. You have the option. Even to omit the particular table. This table you can omit. You can write it down just like that. But I prefer to use table, so I have used this tabular format. Okay. So these are the cases that I had used. Then books referred. So whenever you are using any book as your reference or authority, then you have to write these particular things. These are the most important things. Book name, what book you are using. I had used Charter Constitution of India, author was Dr. Durgadas Vasu, edition was 15th, and year was 2019. Another section you can add in which phase you have used that particular book. I was running out of the time and my deadline was close. So I didn't get the time to write the page number. So I had omitted, but you can write the page number in which you have used the book. Okay. If you had used the Charter Constitution of India, for example, in the page number 9, then you can add another section here, column here, and you can write in page number 9, I have used this book. That will make your reference more authenticated. Okay. So these are the basic details. You cannot just write that I have used Charter Constitution by D.D. Basu. No, you have to write the edition. You have to write the year of that particular edition. If there is any reprint, then you can also in bracket write reprint 2019. Here, if the original edition came in the year 2018, but reprint was done in the year 2019, then you can write bracket reprint 2019. So it will make your source more acceptable. Okay, these are the books referred. Then you can write the statutes or the acts that you have used throughout your memorial. I had used this kind of these statutes. Okay, Constitution of India is not a statute. It is the supreme law of the land. It is the father and mother of all the statutes. But still, I have enlisted under the statutes, and it is not wrong as well. You can write Constitution under statutes, but you have to remember, Constitution is not a statute. Constitution is supreme law of the land. Okay, except that I had used all these acts. You have to write as to in which year these acts were passed. For example, Indian Contract Act. You all must be knowing it was passed in the year 1872, and it was the statute number 9. It means it is the 9th legislation of the year 1872. And similar in the case of Indian Partnership Act. It was passed in the year 1932, and it was the 9th act or the 9th legislation of that particular year. Okay. After that, you can write the websites here or the online sources. And not only these websites, but also the online sources like articles, books, ebooks. You can enlist all those things under here. So whenever you are using an online authority, it is always advisable that you use another thing. Here, after writing the website or the reference, please write. Okay, please. Sorry. 1 second. Just a minute. Yes, whenever you are using an online authority, after writing the HTTP or the URL, it is advisable that you use in which state you had last accessed a particular website. For example, I am using LiveLaw. It will be more authenticated if I use a bracket, and in that particular bracket, I write that last accessed on, for example, 25th September 2021, time 7:08 p.m. Okay, so that will make your source more authenticated. And why the time is written? Because online sources are susceptible to change. They can be changed, they can be edited. If you're using Wikipedia, that can be edited. If you're using LiveLaw and Bar and Vince, the admins can change their page. So if you're using these authorities and after some days, after submitting this particular petition to court, they find that these particular authorities are not there in the website, then it is your liability to prove that actually you had got that particular point in these websites, but that is not available today. So if I am using something from LiveLaw today in September 25, 2021 at 7:09 p.m. So something is there on LiveLaw which is supporting my case. Okay, so I have used LiveLaw, but I don't use the timestamp. The thing that I should write in the bracket that last accessed on the time and the date. Okay, if I don't use that, then I will be liable to the code. I will be answerable to the code as to what happened to my source if it changes in the upcoming days. Okay, so it is always advisable whenever you are using some online authority, please put the timestamp. That will make your case more stronger. If something is changed, you will not stay liable for that. The code will accept that something has been edited, and that's why it is not available today. Okay. Do you have any other doubt in this index of authorities?
So can I?
Yes, please.
So actually, okay, how many days should we generally give to prepare a memorial?
It is
The type
complete.
and everything.
Yes.
How much time does it take actually? Like, is it possible within 1-2 days or?
Actually, it depends upon who is preparing the memorial. If the person is experienced enough, he has samples of memorials and he is quite handy at preparing memorials, then it will take a very less amount of time. But if you are a beginner, you have never drafted a memorial ever before, and you are getting a proposition and you are trying to draft a memorial, then it is always advisable you take at least 10 days, because there are several editing that has to be done before submitting the memorial. But if you are experienced enough, you have done scores of moot courts, then you can handle that and you can draft a memorial within 1-2 days. Still, sometimes get very difficult because we face a lot of difficulties while facing the deadline. So it is always advisable to you to at least reserve 10 days for drafting your memorial. But it is always upon the discretion of the organizers. It is upon them as to how many days they are going to give you. If they give you less amount of time, then you have to manage that. But in National Moot Court Competition, you usually get at least a month or two. So that will not be a problem. Whenever you are getting a proposition, don't waste time. Do your research, basic research, and start typing. Because these editing parts take a huge amount of time. So you have to be very much cautious about that. If you are thinking that you will do the argument advanced, then editing will take you just 1-2 hours. Then you are committing a huge mistake. It will take you a day or two. I must put a caution here. Is it clear?
Sir, thank you, sir.
Yes. Okay. Then we got the statement of jurisdiction. Okay. So here we can see the index. Here we have statement of jurisdiction in the third. So here we can go after index of authorities. Here it is the statement of jurisdiction. Yes. So here you just have to write under which provision you have approached the Honorable Court. It is quite similar to what you have already written on the cover page. So you just have to explain under which provision you have approached the Honorable Court. For example, if I am appearing for the petitioner in this particular case, so I have to write that the petitioner, the humble petitioner, has approached this Honorable Court under Article 32. For example, Article 32. Here I have used Article 142. But for example, you can take you have approached the Honorable Court under Article 32. But if you are a respondent, then you will not write. The petitioner can write that the petitioner has approached this Honorable Court under Article 32. But if you are a respondent and if you are writing your statement of jurisdiction, then you have to make some basic changes. Like you cannot write that the respondent is appearing on behalf, the respondent is appearing under Article 32. You cannot write that because the respondent never appears. Initially, he never appears under any particular jurisdiction. The petitioner is the person who is responsible for filing this petition. If a writ petition is filed in a court, then the petitioner, who is the petitioner, he files the petition. And after getting the petition filed, the registry enlists that particular case before a particular bench after consulting the Chief Justice of India. Or if it is before the High Court, then after consulting the Chief Justice of that particular High Court. And when the matter is enlisted before a bench, the bench then issues notice to the respondent. For example, if my property has been attached or my property has been acquired by the government agencies and I have not been paid my due compensation. Okay, so I have filed a writ petition under Article 32 to the Supreme Court of India. They got my petition. They will see my petition. Then they will issue notice to the authorities who have who had acquired my property. Okay. So after getting that particular notice, they are the respondents. They are the opposite party. I am the petitioner. They are the opposite party. So after getting the notice, they are duty bound to respond to that particular petition. Whenever court issues a notice to the respondents or the opposite party, the court also attaches a particular copy of that particular petition. Okay, if I am approaching under Article 32 for that particular acquisition, illegal acquisition, I was not paid my due compensation, and court issuing notice to the government authority for being implicated as a respondent, then the court will also attach a copy of my petition with that notice, and it will be sent to the respondent. After getting that notice and my petition copy, the respondent will respond to that. He is called as respondent only because he responds to something. He doesn't appear or approach a court for redressing his grievances. Okay. Petitioner is the person who is responsible for appearing before a court initially, and he is the one who approaches the court for redressal of his grievances. The respondent only responds to the grievances that has been made on behalf of the petitioner. Okay. So here the government authorities, in my example, the government authorities only respond that honorable court, you have issued me notice. So I am approaching for you just as the result of the notice. Okay. So when I am writing the jurisdiction on behalf of the respondent, I have to write here the honorable court. The humble petitioner or the petitioner has approached this honorable court under Article 32, and the notice of the same was served to me or to the respondent. Hence, the respondent has appeared before this court as a response to the same. Okay. But petitioner, you can write just only a line in the statement of jurisdiction, like the petitioner has approached under this provision of the Constitution or any other statute under which you are appealing. If you are accused and you are appealing to the High Court, then you can write also this particular appellant is appearing on behalf, under Article 374, Section 374, Clause 2 of the Code of Criminal Procedure. But if you are appearing on behalf of the state, who is the respondent in that particular case, then you have to write that the accused has appeared under Section 374, Clause 2 of the CRPC, and the notice of the same was served upon me or the respondent. Hence, the respondent has appeared before this court to respond to that particular notice. Okay. So this kind of editing should be done on behalf of the respondent. For petitioner, you have to write just only a line under which provision he has approached this honorable court. Okay. Is there any doubt?
Sir, do we need to add the provision in totality?
No need to add the provision in totality. I have used a footnote here. You can see Article 142(1). Here I have explained the entire provision. There is no need to explain the entire provision. You can only write the provision. You need not explain the provision. I have used here the entire provision only because it will convenient for the court. But if you don't use that particular provision or you don't explain the entire provision, that is not going to hamper your case in any way. Or you can only use that particular clause. For example, if I am appearing in the High Court for criminal appeal and my relevant clause is 374 clause 2. Clause 2. I am not concerned with clause 1 or 3 of that particular section. I can only write clause 2. I need not write clause 1, clause 2, clause 3. I have here written all the clauses of Article 142. It is unnecessary. It is only for the convenience of the court. If you write, it is not wrong, but it is not necessary. If you omit to write that, also the court will check the whereat. They will see whether actually the provision is correct or not, or if you are using the correct provision or not. Okay. So after that comes the statement of facts. Debashish has very lucidly explained you as to what should be written under this particular section. He has said that you have to differentiate between material facts and immaterial facts. Okay. So I have written here the brief facts of this case, which are material. I haven't used any fact which are immaterial. So I have to identify which facts are really not necessary for my case. So I can just exclude those cases from the statement of facts. Okay. I have here just written all these facts which are really necessary for the determination of this case, like the background of the case. It is necessary for the court to know the background. Without knowing the background, it will be difficult for the court under which context it is going to decide the case. So I have written the background in a very short manner. The proposition was of 8 or 9 pages. I had to brief it within 2 pages. Okay. I have it is upon my discretion to use these kind of headings. Okay. It is not compulsory that whatever language is used in a proposition, you have to write that. It is always desirable, it is always advisable that you use your own languages to convey the idea of the proposition. Okay. Even if you are not using the correct or the exact words, it is not an issue. If you are conveying the idea, you cannot twist the facts. You have to always remember that you cannot twist the facts or you cannot hide the relevant facts. You can always change the wordings, but you cannot change the essence. Okay. So you, for example, I have written here, partners received a notice from law firm of New York. The proposition could have written that New York, when the firm based in New York had sent notice to the partners. I used something different. I used some different words like partners received a notice from a law firm of New York. So the essence remains the same. You can change the words, but you cannot twist the facts. You cannot change the facts. If something is very clear from the proposition, you cannot hide that. And another thing that you have to always remember about this statement of facts, no matter whether you are appearing on behalf of the appellant or the petitioner or the respondent, okay, you have to disclose all the relevant facts, even if those facts are going against you. It is really advisable for you to use the correct facts. You should not hide any relevant facts. If it comes to the notice of the court that you are using some twisted facts or you are hiding some relevant facts for the benefit of your party or your client, then it can be very harmful. The court can dismiss your appeal or your petition. It can impose costs on you, or it can also order for imprisonment for contempt of court. Okay, so it is always advisable to use the correct facts and always disclose the material facts. Okay, and there, as Debashish said, you have to differentiate between what are the material facts and what are the unimportant facts. You can exclude the unimportant facts, like Debashish said. In many propositions, you will find a particular line like India got its independence in the year 15th August, on the date 15th August 1947. So it is immaterial. The date of independence is immaterial for your proposition. If it is a criminal matter, if it is a criminal appeal, what we will do of the date of independence? It is immaterial for the decision of your case. So you can exclude that particular line. Or whether if you are appearing in a constitutional matter, okay, and there are some lines which are not relevant to your case, which are some criminal nature, which are actually of no value to your case. You can very well exclude those particular lines from the statement of facts, and after that you can brief the entire fact into 2 or 3 pages. Okay, never extend your facts beyond 3 pages. It is always advisable to summarize your facts within 2 pages. That is the most ideal form of summarizing your statement of facts. So is there any doubt until now? Is there any doubt? Or I should assume that you have understood?
Yes, sir, all clear.
Okay, okay. After
So
that?
can I?
Yes, yes, please.
Sir, in statement of facts, as you mentioned, that it is the moot proposition was related to constitutional law. In case it is related to criminal law, then sir, you have just put some heading like that. So in statement of facts, we are going to write what we have understood, or we are going to write what is given in proposition, and we are going to relate it to what we have understood.
No, it is whether it doesn't matter whether it is a criminal matter or constitutional matter or civil matter. You have to give the essence of the proposition. You can use some other words or the synonyms of some words, but you have to give the essence. If it is a criminal appeal, if the accused has gone in a criminal appeal, you cannot change the word to mean that he has gone under writ petition. So you cannot twist the facts or twist the jurisdictions. Unless and until you twist all those material facts, it is always permissible for you to use synonyms or similar words. These are under your domain, you can use that. It doesn't matter whether you are appearing in a criminal case or a civil case or a constitutional case. In all those cases, you have to write what is the essence of the proposition. You can use your own words, not what you understood, but what the proposition wants to convey. What you understood is something different. You may not understand everything of the proposition, but you are duty bound to disclose every material fact of the proposition in your statement of facts. So the the basic idea of drafting the statement of facts is you have to disclose the essence of the proposition and not merely what you have understood. Is that
And
clear?
sir, we are going
Yes.
to disclose both the sides in case we are writing from both respondent side also.
Yes, yes. In a national moot court competition, you have to draft memorial for both the sides. So it is a doubt of many participants that whether it is permissible to use same set of facts for both the sides. Yes, it is permissible and it is always advisable as well. You have to use the facts, the same facts for both the sides, because it doesn't matter whether the facts are going against you. You have to justify that even after even after the facts are going against me, still I can justify my cause and I can get a beneficial order in my favor. Because the motive of disclosing all the facts is that you cannot hide anything material from the court of law. If something is hidden or something is not disclosed and the court finds it later on, then it can be of heavy consequences. Like your case can be dismissed, you can be convicted for contempt, you can be convicted for misleading the court. Is that clear?
Yes, sir. Thank you, sir.
Okay, okay. So then comes one of the most important sections, issues raised. So what are the issues? It is a real problem with many mooters, many junior mooters actually. They go through the propositions, but they don't find relevant issues. So how to find issues? So whenever you will read the Evidence Act, the Indian Evidence Act of 1872, there will be a section that will be headed as interpretation section, and there is the interpretation clause which says what are facts in issues. Similarly, there can be two kind of issues on facts and issues on law. Generally, in the lower courts, like the subordinate courts, which are under the district court category. So, in those cases, in those courts, you can argue on the issues of facts actually, both issues of facts and issues of law. But in constitutional court, like in High Court and Supreme Court, it is better if you don't agitate the questions of fact, because in the constitutional courts, they are only concerned with the questions of law. They assume that the facts of the case are already settled and there is no need to re-agitate the facts. So it is better if you settle your facts at the basic level itself, in the district level. So whenever you are appearing in a trial before a trial court, in a criminal court, you are conducting a trial. Okay, so you can cross-examine, you can chief-examine your witnesses. Okay, so in those cases, you can cross-examine and chief-examine and get your facts collected. And you can also argue on the points of facts. If you have any doubt in the points of facts, you can agitate it before the lower courts, and they will consider your facts, and they will also amend the facts if it is necessary. Okay, but in the higher courts, like in the High Court and Supreme Court, it is not permissible always. It is only under the extraordinary jurisdiction of the High Court and Supreme Court that you are allowed to agitate the points of facts. Otherwise, you will be advised to keep yourself confined to the questions of law. Okay. For example, you can say in the trial court, in a criminal case, for example, take I have killed someone using a knife. Okay. This same thing can be agitated in a trial court. The trial court will examine witnesses to verify actually what I am saying or what the witnesses are saying true or not. But in a high court or in Supreme Court, in the Supreme Court, the same thing cannot be agitated. You will not find a witness box in the High Court, or you can find a witness box in the Supreme Court. It is only used in extraordinary cases if it is absolutely needed for doing complete justice. Otherwise, they will not entertain to examine or cross-examine your witnesses. They will rely upon the documents which are already settled at the level of trial court, and they will only agitate the points of law. Okay, they will not hear you on the points of facts. If you say after you are convicted in the trial court, you will come to the High Court and will tell that actually in that particular case, I had not used a knife, I had used something else. That is a point of fact. The High Court is not considering that. High Court will consider whether the conviction, for conviction, the trial court has actually taken into consideration the evidences that were recorded and that were on record. Okay, and whether the provisions were correctly used or not, and whether the case laws or the precedent are correctly used or not. They will not consider whether there is a factual error or not. Okay. So while determining the issues, you have to read propositions again and again. So whenever you get a proposition, try to read as much time as possible. Every time you will get something new. I can assure you, whenever you get a proposition, read it as many as time it is possible, and you will get something new every time. Okay. So what facts can be taken into consideration as issues? Okay. Whenever there is a particular point of fact or a particular point of law in which a particular party will say that yes, it happened, and the other particular party will say no, it is not happened, it has not happened. Okay. For example, I can take this particular issue, it will be convenient. Okay. Issue 1 here, whether the instant transfer petition is maintainable before the honorable court. So the petitioner will say that yes, sir, it is maintainable. And the other party, that is the respondent, They will say, no, it is not maintainable. Here it is a dispute between two parties. So you have to find out the disputes within the facts. The things which are disputed in a particular set of facts can be taken as issues. To put it simply, only the disputed facts, only the disputed points can be taken as issues. The points which are affirmed by a party, which can be affirmed by a party, and a point which can be negated by a party. Okay, if a point is there upon which a party will agree that yes, it happened, and the other party will say no, it didn't happen, then it can be taken as an issue. If there is a settled fact upon which no party is disputing. For example, in a criminal case, if it is not disputed that person X was murdered, then it cannot be taken as an issue. You cannot take this issue that whether person X was murdered. If it is settled, if both the parties are saying that yes, person X was murdered, but it is in dispute whether person Y killed him or any other person killed him, that can be an issue, because the culpability of person Y is in question. It is disputed, but the fact that person X was killed is not in dispute. The questions which are not in dispute cannot be taken as issues. The only questions which are in dispute, and by dispute I mean a particular party will say, the petitioner will say yes, it happened. The other party, the opposite party will say no, it didn't happen. In those circumstances, and those particular questions can be taken as issues. If something is already settled, something is admitted by both the parties, then that particular point cannot be taken as issues. Here you can see the second issue, whether the contract is enforceable against the petitioner. The petitioner will always say, yes, it cannot be enforceable against us. But the respondent will always say, petitioners are liable and this particular contract can be made enforceable against them. Similarly, issue number 3, the contract can be made enforceable against the petitioner. Okay. The petitioner will say something that will be negated by the other party. Here it is a dispute. So the primary thing that you have to do for finding out the issues is that you have to see how many disputes are there, how many points are there upon which both the parties will not come to an agreement. You have to carve out all those facts, then you can frame your issues conveniently. Never take a particular point which has been already settled or which has been already admitted by both the parties as true, because that is not going to be an issue before an honorable court. Always find out the disputes. Do you have any other doubt on the points of? Yes.
Can I?
Yes.
So, for example, in case of if we have some sometimes I would say in some cases electronic evidence is not considered. Like there are some rules, like some evidences from CCTV or something like that will be considered, and something will not be considered. So evidences can be included in issue or not.
Yes. In the case of electronic evidences, there is a concept called electronic evidence certificate. So you can make an issue whether the electronic evidence certificate is admissible or not. Okay. If something is already recorded in a CCTV and that is available before the honorable court, then that cannot be made a dispute, because that is quite apparent, quite evident. You can make this as an issue that the electronic evidence certificate that has accompanied the electronic evidence, whether it is admissible or not admissible. One party will say yes, it is admissible, so the electronic evidence can be taken as an evidence. The other party will say no, electronic evidence certificate was not admissible, so the evidence cannot be taken into consideration. Did you get it?
Okay, so thank you, sir. One more doubt.
Yes.
Sir, issues raised will be same for both the parties or it will be different? if we are going to make
Actually,
two members?
yes. So whenever you go in National Moot Court competition, you have to draft a memorial for both the sides, because your which party you are going to represent will be decided by draw of lots. I will tell you what is the procedure, but you are expected to draft memorial for both the sides. So whenever you are drafting memorial for both the sides, always keep the issues same for both the sides. But when you will participate, you will get another party. Another party will appear against you. So you have kept these issues. Many propositions propose, they already propose the issues that they want to discuss. But in many other propositions, you will get that there is no issue. You are given discretion to find out your own issues. When this is the case, then you have to find out your own issues, and it doesn't matter whether those issues that you have carved out are the similar or same with the opposite party which is appearing against you. If it is not the same, then it is also not a problem of yours that can be managed. But if you are drafting memorial for both the sides, it is always advisable that you keep issues of both the sides same. But whenever there is no particular issues drafted in a particular proposition, and it is given to your discretion that you can find your issues of your convenience, then it is always not the same that each and every participant will draft. So it is always susceptible to differences. That is not a problem at all.
Okay, sir. Thank you so much, sir.
Yes, thank you. So these are the issues raised. Then comes the summary of arguments. Okay, summary of arguments is a part which you should draft at the end of the memorial. I will always advise it. After doing the argument advanced, you come to the summary of arguments, because unless and until you know what you are arguing or what actually you are writing under the section argument advanced, which comes up to summary of argument, argument advanced, then you cannot draft the summary. You have to know the arguments. After knowing the arguments, after knowing the essence of the arguments, then you come to the position to draft a summary. Without knowing the arguments, it is not expected from you to draft the summary. So skip the summary part for the time being. Directly come to the argument advanced. Okay, as we have already drafted the issues. Yes, for your understanding, I can also say this, that issues are not drafted by participants. In a real court, issues are not drafted by the advocates. Issues are always drafted by the court. And while drafting the issues, the court can take assistance of both the parties, like the counsels of the petitioner and respondent can assist the court in drafting the issues. But the final issues are always drafted by the court. In a moot court proposition, it should be ideally be drafted by the organizers, the court has drafted all these issues for consideration. But if it is not drafted, then you will draft your own issues. But when the moot court just asks you as to who drafts the issues, then you have to answer that the court drafts the issues, not the participants, not the counsels for the petitioner or counsel for the respondent. They are not responsible for drafting the issues. In the competition, for the timing, you are drafting the issue. But in real court, the court is responsible for drafting the issues. Okay. So these are the issues. Under issues, you have to keep sub issues. Here, for example, you can see I have kept this issue. I have already drafted my issues in the issues raised. Here I have written the first issue, whether the instant transfer petition is maintainable before this honorable court. Under that particular issue, I can write certain sub issues, like this is my sub issue. The honorable court has jurisdiction to transfer the suit under Article 142. So in the sub issues, the basic thing that you have to write is that the sub arguments or subsections that you can put under a particular argument. Article 142 maintainability is a very broad area. So you can divide that area into many parts to justify your arguments. For example, I have written here the Honorable Court has jurisdiction to transfer all suit under Article 142. This is the sub issue. Here I can discuss as to why it has jurisdiction. Similarly, second sub-issue you can see here, the transfer of suit was effected to achieve complete justice between the parties. So I have given another reason as to why it will be maintainable. So issue is a broader term. Sub-issues are the reason why issue should be justified. Okay. You can take more and more sub-issues. You can take up to 10 sub-issues even in an issue. Okay. So sub-issues are actually the parts which justify why your issues are justified. Sub-issues always try to convince the court as to why your issue should be decided in your favor. So you can divide your issue into multiple sub-issues for the convenience of the court. Okay. Similarly, you can come to the second issue here, whether the contract is enforceable against the petitioner. I have kept another sub-issue here. There is a valid contract between petitioner and respondent. So I have divided the issue into further subheadings. And under sub-issue, you can also keep sub-issue. It is not compulsory that you have to keep only sub-issues. You are also allowed to keep sub-issues. Like here I have written issue 2. Here's issue 2.a. I can also write under issue 2.a, issue 2.a.1. That will be my sub-issue. You can take as much as sub-issue you want to justify the cause of your case. The primary aim is to convince the court that you are, the primary aim is to convince the court that your case is justified and the judgment should be given in your favor. For that, you can divide the issue into further sub-issues, sub-issues. It is upon your discretion. Okay. So similarly goes the argument advanced. And what should we put in argument advanced? That has already been dealt by Debashish. He has said how you will do research. After reading the proposition, I have already said the disputed points will be included in the issue. So after finding out the issues, you have to do extensive research on those issues. For example, maintainability of Article 142. Debashish has explained how you will find cases on the point of article, a particular article or a particular section or a particular point of law. You can put the keywords in the Indian Canon or SCC or Manupatra. After that, you will get extensive pieces of judgments. And from those judgments, you can get detailed information. Actually, what is the position of law in the contemporary times. So after obtaining the position of law, you can write it down in your own words. Never copy paste. Paraphrase it, but don't copy paste it. If you copy paste it, then you will be liable for committing plagiarism. So that is not acceptable at the national and international levels. It can be managed in the state level or local level, but never commit plagiarism in national and international level. Okay, so paraphrase it, keep it simple, keep it in your own words, keep the essence same. Whatever you are doing in the statement of facts, do exactly the same in the argument advanced. Take out the essence from the cases after researching extensively in Indian Canon, SCC and Manupatra. After going through the entire judgment, keep out the essence or take out the essence and write down those essence with your facts of the case in the argument advanced. For example, I have got some cases on the admissibility of petition under Article 142. Okay, so I have got the principle under the principle which govern the petitions under Article 142. I can use those principles and I can implement those principles into the facts of my case. And I can use those things and I can paraphrase those things into the argument advanced section. And that's how I make the argument advanced. Here, you cannot take the parts of the article or parts of articles or parts of judgments. It is not desirable because it will be invalidated for plagiarism. So always try to keep it unique. Keep it in your own word, paraphrase it, simplify it, but keep the essence same. If you are writing something on homosexuality, for example. Take for example, you are writing something on homosexuality, and you are saying that homosexuality is not an offense in India. Write it simply that homosexuality is not an offense in India. You need not write the exact words what has been written in the judgment. You have to keep the essence. Section 377 of IPC has been struck down partially. So you can write that homosexuality has been decriminalized. You can use your own words. You can use synonyms, but keep the essence. You can write 377 has been decriminalized. You can write homosexuality has been decriminalized. Same-sex consensual activities are decriminalized. You can use these kind of words, your own words. And for reference, for authority, for every point you have to give an authority, because your arguments without authority has no value in court. Okay, in a debate competition, you will give an argument and that will be accepted by the jury. But in case of moot courts, for each and every argument, you have to give an authority as to why your argument should be accepted. If I am saying that in a particular case, my client is innocent and he should not be convicted for homosexuality, then I have to say as to why he should not be convicted for homosexuality. The reason is he has committed no wrong because the homosexuality has been decriminalized. Okay. And for that, I can cite the case Navtesh Singh Johar versus Union of India with citation. In this fashion, I have to draft my argument advanced. All these things that you can see here, the paras, these are the paraphrasing. These are not the exact paras or exact words of the case or exact words of any articles. If you take exact words, then your memorial will be disqualified. Your team will be disqualified for committing plagiarism. It is always, yes.
So sorry to interrupt, sir. Actually, in case we are referring to a case only,
yes,
then also we are not going to copy. We will read that case. We will try to paraphrase it, rephrase it, but we should not copy the same thing that is mentioned in the case.
Yes, I got you. So if it is quite necessary to quote the exact words of the judgments, then you can put in the quotation marks. You can put the quotation marks and then you can write that. I have done it here as well. I can show you. Okay, maybe in any other memorial. Sorry. If it is absolutely essential that you have to use the exact words used by the judgment or some particular judge, then you can put quotation marks. Then it will not be considered as plagiarism. But otherwise, if it is not essential, then please paraphrase it. Don't use it exact what it is written in the judgment. But if you put quotation marks and give proper citation, then it will not be considered as a plagiarism. You can take those things.
Okay, sir. Thank you, sir.
Yes. But try to use less number of quotations. Multiple quotations are not very accepted in our fraternity. So take out only the most important quotations. Otherwise, always try to paraphrase or use your own words, your own interpretations using authorities. Okay. So these are the things. Yes, one thing more. Whenever you are drafting an argument, you should always focus on your particular set of facts. People are there who always focus on the case laws and what has been held in different kind of cases, and they directly jump to the cases. That is not the right approach. You have to see what is the facts of your own case, and you have to use those facts and use the principles of law, the settled principles of law. You have to use those things primarily, and the cases are only for corroboration or for authority, for justification. The cases are not primary materials. In your argument advanced, also in your oral advocacy, it is always advisable that you use your particular points of facts, whatever fact is written down in a proposition, refer to your proposition first, then apply some legal principles to the facts of your case, and to justify that particular legal principles and facts, you can use case laws for corroboration. Don't come to the case law as primary resource. Okay, while you are drafting an argument, for example, takes that particular homosexuality. For example, if you have got a proposition where a person is convicted for homosexuality, you are appealing against that particular judgment which convicted the accused for homosexuality in the High Court. So in criminal appeal, you are drafting the petition for the accused. So write what are the facts of your case. First write what are the facts of your case. Then write the legal principles. For example, you can write Mr. X was caught in a very suspicious manner, and he was apprehended by the police officers. You can write these kind of facts, whatever is written down in your proposition, and then you can use the principle. Though he was arrested on the ground of committing homosexuality, but still he should not be punished for that, because the homosexuality has been decriminalized. And for corroborating the particular position of law that homosexuality is decriminalized, you can use the case law Navdesh Singh Johar versus Union of India. Okay, first use your own proposition, your own points of facts. Use the legal principles then, and at the last you have to use the case law only for corroboration and support. Never come down to the case laws first, because court is not concerned with whatever is held in a particular case law. Court can find it out from reporters as well. You need not convey the court that it has been held in this particular case. Court is not concerned with that. Court is concerned with your case. Why you have approached the court? Why you are consuming the valuable time of the court? So always try to justify your case using these particular authorities. That is the essence of the argument advanced. Don't jump to the cases first. That is the crux of the argument advanced. Is there any doubt?
So can I?
Yes, please.
So that means first we should refer to the facts.
Yes.
Then we should research for the cases that are related to those particular facts. Not we should first go for the cases and see कि इस section के अंदर ये है तो उसके हिसाब से अपने facts we are not going to frame. So
Yes.
like it should be first we will see the facts and then we are going to.
Yes. First of all, you have to see your facts. Whatever your facts are saying, accordingly you have to find out the legal principles that can be made applicable to your facts. You can use those legal principles, and to justify why you have used these legal principles in your set of facts, you can give a case law. This is
Okay,
the
sir. Thank you,
yes.
sir.
Thank you. So this is the crux of argument advanced. Does anyone want to say anything? Or do you have any doubt? Anyone? Anyone? Do you have any doubt regarding?
So not with respect to case laws as such, but so what is like the format of drafting? Like for an essay, we go with introduction, then content, and then a conclusion and all those stuff. So what is the format for drafting an argument?
Okay. So as I said, you have to first look for the facts of your case. So as long as you are focusing on the facts of your case and trying to implement the settled legal principles using some authorities, there is no particular format. It is up to you how you are writing. But the primary thing that you have to keep in your mind before drafting the argument is that you have to focus on your fact. Then you have to, after considering your facts and circumstances, you have to carve out the legal principles that you are going to use, and for corroboration, for justification as to why you are using those legal principles to your fact, you have to find out some case laws. As long as you are following this particular method, it doesn't matter how you are writing, whether you are giving any introduction. There is no need of introduction. There is no need of any literature showing your skills of literature in a argument advanced. You can directly come to the point. You are always advised. It is always advisable to you to directly come to the point. Don't go anywhere else. Don't write literature. Don't write that India got independence on 15th August 1947 or anything else. Come to your point. Come to your fact. Directly, you can see here. I have written in the. It is the starting of issue 3. Okay. I have written the title of the issue. Then I have written it is most humbly submitted that these are the sub issues. Okay. Then I have started the sub issue. I have come to the point. Directly I have come to the point. It is true that under Partnership Act 1932, a firm or partnership is not a legal entity, but it is merely an association of persons. So I'm trying to say that it is the essence of the act, and by using that essence, my set of facts are justified, or my contentions are justified, and for that I am using some authorities like case laws or commentaries or some expert opinions. Hence, my argument should be accepted by the honorable court. So as long as you are following all these methods, there is no definite format for drafting argument advanced. It is up to you. You can be innovative as well. You can write something else as well, but don't come to the case law first. It is the primary advice I can give. Is that clear?
Yes, sir. Thank you.
Yes, thank you. Then it is the conclusion of the argument advanced. It is the most important part, the most vital part. Then Dr. Ambedkar said that Article 32 is the heart and soul of the Constitution of India. I always say that argument advanced is the heart and soul of the memorial, Moot Court Memorial. Okay. After that comes the relief part. Yes, before the relief, you can come to the summary of arguments. After doing your arguments, after writing your arguments, you are now clear as to what you have written and what contentions you are going to make in the court. So you have to give the summary here. Just before argument advanced, you have to give a summary. And given the summary in the form of sub-issues. You can also write the summary in your own language. It is not always advisable to write the sub-issues. You can write the essence of the arguments in your own languages in 3-4 lines, not more than that. Okay. So summary of arguments is written only for the understanding of the judge, because the judge is not expected to go through the entire memorial within a very definite period of time. Very particular period of time. So it is not desirable. So the judge can get the essence of your arguments from the summary part. So always carefully draft the summary of arguments after completing the argument advanced part. Don't get in a hurry. Always be cautious and draft the summary of arguments with greatest introspection and caution. Always try to write only those things which will give a brief idea of your case to the judge. Okay. The crux and the most important points of your argument advanced, you have to write in the summary. It is the essence of the summary. Most important points of the argument advanced. Don't use case laws in the summary of arguments. Case laws are only for the argument advanced. Just arguments, the only arguments, the most important arguments can be summarized. Don't write the entire argument. Only summary of arguments you can put here after drafting the argument advanced. Okay. Lastly, we come to the prayer. It is the format of the prayer. Okay. You have to write, wherefore, in the light of issues raised, argument advanced, and authority cited, it is most humbly and respectfully prayed and implored that may this honorable court be pleased to kindly and graciously adjudge, adjudicate, and declare. So it is the formality, 2-3 lines that you have to tell the court, honorable court, that after examining all these arguments, all these authorities, and all these facts, the honorable court may pass these 4 or 5 reliefs. So I can advise you to give one relief for each argument, each issue. Okay. My first issue was whether the petition under Article 142 was maintainable. So my first relief should be the transfer petition is maintainable before the Honorable Court, and accordingly you have to give a particular relief for a particular issue. Okay, this is the essence. If there are 4 issues, then you can keep 4 reliefs or 4 prayers. You can also keep more than that, but if you keep 4 prayers, then that will be okay. Okay. The number of issues for each issue you have to write a particular prayer. After that you have to write or and public or the Honorable Court may pass any other order as it may deem fit or deem appropriate in the interest of equity, justice and good conscience. So the purpose behind writing this line is that you cannot force the Honorable Court to pass any order in your favor. It is upon the good judgment of the Honorable Court to pass any kind of order. You are always obliged to whatever the Honorable Court is doing. So you always say that Honorable Court may pass also any other order as it may deem fit. After that, you have to write all of which is most humbly and respectfully submitted. Whatever you are submitting to the Honorable Court, you have to do that respectfully. You cannot vilify the authority of the Honorable Court or the majesty of the Honorable Court. You have to always submit to the authority of the Honorable Court as a counsel, also as a client. After that, you have to write SD, the signature of the counsels. If there are multiple counsels, you can write counsels for the respondents or counsels for the petitioners. And here in the left side, you have to write date and place. Place means in which city your court is located, and date means on which date you are filing this petition. Otherwise, in moot court, on which date you are appearing in your oral arguments. This is the essence of a moot court memorial. These are the basic parts of the moot court memorial. Is there any doubt regarding any part of the moot court memorial?
So can I?
Yes, please.
Sir, like what should be the limit of the entire memorial? Can it be 20 pages or 25?
Okay. So it is also upon the discretion of the organizers. Organizers give the rules and regulations for drafting memorial. So you will find some rules which will say that you have to confine your argument advanced, only the argument advanced section, not the entire memorial, to 20 pages or 25 pages. In some other moot court competitions, you will find that they will say you have to confine the entire memorial to 40 pages. And within that, whatever page you are taking for argument advance, it doesn't matter. But nowadays, it is the trend that they will prescribe a particular page limit for argument advanced, like 25 pages or 20 pages, and a maximum page limit for the memorial. So in a national moot court competition, you can expect anything between 30 to 40 pages for the entire memorial. And for argument advanced, you can expect anything between 15 to 25, not more than 25. Is that clear? Yes. So I will advise whenever there is a prescription for keeping your argument advanced to 25, then you can take it up to 25, but use less number of authorities. Like use only the point-to-point authorities, and don't use any authority which doesn't have any bearing upon your case. Keep the authorities short. That will help you to limit your pages. Otherwise, if you take 25 pages and use 300 case laws to justify your arguments, then it will be very difficult for you to limit your pages to 40, because index of authorities will take a lot of pages. And except index of authorities, there are so many formalities that we have to do, like cover page, abbreviations, jurisdiction, issues, facts, prayer, all these things are also there. So you have to keep a check on the number of authorities that we are using in a moot court competition. But if the highest limit is something written, never ever cross the highest limit. If it is written that you have to confine your argument advance to 25, never go to the 26th page. It will attract some negative marking. If it is written that the entire memorial should be within 40 pages, never go to the 41st page. It will attract a penalty. So that is done in a National Moot Court competition. So is there any other doubt?
So one more, sir.
Yes.
Everything can be done in MS Word only, right?
MS Word, yes. MS Word. And after drafting your entire memorial, please convert it to PDF and send the PDF version as well as Word version. Because you can see in MS Words, there are several editions like 2010 edition, 2013, 16, 19. So for each and every edition, there is a modification and pages are different for each and every edition. So it causes difficulty for the organizers to evaluate your memorial if their edition is something different from your edition. So if you convert it to PDF, it will be convenient for all. But always send your Word document and PDF document, both the documents, to the organizers.
Thank you, sir.
Okay. Is there any other doubt?
So, like while giving the prayer, they often ask us that how is the court authorized to grant you these prayers? So what is the authority? So could you please like tell them which articles or sections authorize Supreme Court to give any judgment or High Court to give any judgment?
I didn't get you. Please.
मतलब ऐसे judges पूछते हैं ना कि okay, you've given these prayers, but how are we empowered to give these prayers? Like which article of the Constitution empowers us to grant you these prayers?
Actually, there is no definite article which says that the court has to grant the prayers. For a writ petition under Article 32, it is written in the particular article itself that if there is any violation of fundamental rights, then the court can grant some writ or order or directions. So these writs, order or directions are in itself the authority to grant some reliefs to the parties. Okay, it is for the writ petitions. And for criminal appeal, the particular provision which prescribes that an accused can go to the High Court or any other court in appeal against the conviction. It is the inherent provision which also justifies it, which also gives power to the court to grant the relief. So the jurisdictional provision in this particular case, Article 142 I have used. So Article 142 itself justifies that the court has also power to give me reliefs. So whenever you are confronted with this particular question as to which particular provision provides the court authority to grant your reliefs, you can say the particular jurisdictional provision. It is always there. Article 32 says that you can, the court can grant relief. 226 also says. 142 also says. Even the criminal appeals, those particular provisions also say that they can grant relief. Is that clear?
Yes, sir. Thank you.
Yes. Any other doubt? Please tell us. Any other doubt? I can see only 6 participants. I must appreciate your presence for listening to us. You have any other doubt? Please tell us. We'll definitely try to address that. Okay. So may I assume that you have understood everything about drafting of memory? Okay. Fine.
So can I say something?
Yes, please tell.
Sir, thank you so much. I'm really grateful for such a nice session because it would not have been possible without your patience as well. And I'm really sorry if I have asked a lot number of doubts, but you have clarified and I'm extremely grateful. Thank you so much, sir.
No issues, Divyasri. We are really grateful that you asked us so many important questions. Otherwise, we would have omitted that. I and Devasys, I also thank you on behalf of Devasys as well You have asked so many relevant questions. It is purely interactive only because of the participants like you. Thank you for all those questions.
Thank you, sir.
Yes. So after that, we are left with only one part, one significant part. So I will request Debashish to take over the session and explain the rules of oral advocacy. I will also intervene whenever it is required. Debashish, can you do that?
Yes, sure.
Yes.
But I think just you can stop sharing your screen so that we
Yes.
can come.
Absolutely. Yes.
Yeah, but I think we have almost set for 5 hours now. So we should stop today after completing this memorandum part only. There are a few things that I would like to say on part of memorials. And then we can take compendiums, etiquettes, and oral advocacy thing tomorrow.
Tomorrow at which time?
We will decide that. We will decide that and intimate in the group accordingly.
Yes.
That will be better because there are a lot of things to discuss under them and it will be 11, 12 today. So that won't be practically possible. So let's keep it till memorandum today and we will divide all today's video into separate parts and upload that so that it will be helpful. So now there are a few things that I would like to tell about drafting and editing of Moot memorials, and after that we will close today's session and we will hold other parts tomorrow.
Yes.
Now Jyoti Prakash has almost covered everything that is required for memorials. I would like to ask you people that if you have any doubt regarding formatting all those points, like if you have any doubt in making the table of index of authorities, or if you have any doubt that how you should color the front page to red or blue, or how you should put a header or footer, or any other such kind of doubt. If you guys are well versed with MS Word, then we won't go into that. But if you have doubt, then we can discuss that now.
I think that is a very vital part. We should deal that tomorrow itself, because we can also say how to break the pages. We can also show them as to how to color the front page and header, footer, footnotes. We can tell them tomorrow in detail. I think more participants will be benefited if we hold that tomorrow.
All right. As of now, if you guys have any doubt related to that, then we can discuss that now and we can cover that tomorrow as well.
Yes,
not a problem.
You saw my memorial. So if you have any doubt as to how how that should be done, how the color should be done, how footnote can be put. So
Sir,
if you
I
have any,
observed one thing in your memorial. In at the bottom part, you had written and mentioned the competition name is and the page number side to side. So, is it compulsory to write the competition name in each and every page?
no. The name of competition is not at all compulsory. If it is provided in your rules that you have to write the name of the competition, then you have to write. Otherwise, it is up to your discretion. It is up to your choice. If you want to write, you can write. Otherwise, you can also omit that. There is no problem.
We generally do that to beautify the memorial so that it will look good to the memorial checker or examiner.
Yes, Amisha, you are saying something.
Sir, what are the other important or crucial things which we need to add either on header or footer?
You can divide the memorial into most important parts, like whatever we have divided in the table of contents. So, for example, you can take argument advanced. It is one of the most important parts of the memorial. So you can use the word argument advanced as the footer or header to identify that these pages are of argument advanced. I will show you how you will do that. That is a clumsy process that will take some time.
We can do that. We can do that tomorrow. And even the memorial that I have mailed you, you can see that the point that Jyoti Prakash is saying has been done by that team.
Yes.
They have given in the footer of statement of jurisdiction of that page that it is a statement of jurisdiction. Then index of authorities, all 5-6 pages, they have given the footer that it is a statement, it is index of authorities. And if summary of arguments, then all 2-3 pages summary of arguments in the footer. They have segregated that. That basically, as I said, to beautify your memorial, that will look good.
Yes.
So you can refer to the memorial that we have mailed you, we have given you.
Yes.
And you can see that. And if anybody, if anybody said so, then we can show that even on
Yes.
screen share. That
It will,
won't be.
it will make your memorial more organized. It will make your memorial more acceptable. So these are some points that we will explain tomorrow. If you want, we will show you how to put those sections. Those are some technical things. Though we are not experts in those technical things, but still we'll try to show you, demonstrate you by sharing our screen. And after that, there are also rules for editing, like Oscola Blue Book. We haven't dealt with that today. So if you want us to deal with those parts, then we will also deal.
That will come under the drafting and
Editing,
editing
yes.
thing. So we will do that. As of now, let's wrap up this session, because you guys are also sitting for more than
Yes.
5 hours now. So we don't want to hasten you up for this much time. A few things that I said that I will say now. First thing is Jyoti Prakash mentioned that you have to divide your issues into sub-issues so that your arguments will look more organized and will give a message to the judge that these are the specific points the council will be dealing with. So now there is a question that you should have asked, that how to divide a particular issue into sub-issue. Right. So now I will give you an example and you will hopefully understand that. Suppose your issue says that whether a particular petition filed under Article 32 is maintainable or not. Right. So you know that it is Article 32. You read Article 32, even Jyoti Prakash has explained Article 32 very well. So now to divide that particular issue into sub-issues, you have to see the ingredients of Article 32, under which circumstances a petition under Article 32 will be maintainable. What are the points that has been either given straight away in the Constitution of India, Barrack, or devised by the court in subsequent times. So all those specific answer to the question that whether the petition filed under Article 32 is maintainable will be your sub-issue. Right. It is, you will simply say, you will simply draft that it is humbly contended that the petition, that the instant petition filed under Article 32 is maintainable because the petitioner has locus standi to appear before the court of law, or there is a violation of fundamental rights of the petitioner. The violation of fundamental rights of the petitioner has been done or has been committed by the state, and state comes under the ambit of Article 12 of the Constitution of India. So these are the most basic sub-issues that we generally use while dealing with the issue of maintainability. Likewise, if you say that you are dealing with a criminal law case, and you in your proposition, section 302 of Indian Penal Code has been charged against the accused. So likewise, you have to divide your contention on the basis of the ingredients of 302 on behalf of your prosecution or on behalf of your respondent, if you are dealing with. So you will say that this is the ingredient of the case, and you can take that as a particular sub-issue. Now for appellant side, you can reverse that. You can see the exceptions of that particular section, and you will say that this is the exception of the case. This is not available on the facts, on the materials on record. That's why the accused shall be acquitted.
For example, in the murder case, as Debashish said, 302, you can say there is mens rea. For accused, if you are appealing, if you are appealing against your conviction, you can say there was no mens rea, there was no actus reus. These are the ingredients of 302. So if you challenge that these were not existent in your case, and you divide the issue, there will be issue whether you should be convicted under section 302 IPC. Under that issue, you will give those sub issues like whether there is mens rea, whether there is actus reus. These are the sub issues. If you can prove that there was no actus reus, there was no mens rea, it means it is in your favor. It is in the favor of accused. Okay, so as there is said, for the opposite party, you have to do the opposite. You have to say yes, there was mens rea, there was actus reus. These are the basic things.
You have
Similar,
yeah.
yes. For similar other cases, I can also give an example. If it is a PIL, public interest litigation, then you can say the petitioner has locus standi. You can say there is a violation of fundamental right. You can say there is a public interest. For the respondent, you can say there is no locus standi. You can say there is no public interest. It is only a personal interest. And for the vindication of personal interest, he is coming in the color of public interest. So he should be denied the relief. You can say there is no violation of fundamental rights. He is not representing the larger community. It should be, and on the other side, for the petitioner, you can say he is representing a larger community. And his personal interests are not involved. So petitioner should be given the relief. These are the types. In civil cases, you can do the same. If there is no res judicata, there is no res sub judice, this kind of. You have to find out the ingredients and relevant principles, broad principles that you can put in that particular issue. Yes.
Now, how you will find these particular ingredients? I have already told you in the research method topic when I was delivering upon. You straight away go to commentaries. You will find a lot of case laws enumerating the ingredients of that particular section, or the author of that commentary would have done that for better understanding of that provision. So if you go to Ratanlal Dhiraslal and see 302, in the first page itself, it would have enumerated the ingredients that which should be proved by a party. So likewise, you can find all the sub issues. You have to basically search for a strong answer, a set of strong answers that you will pose for that particular issue, and that will be your essence of argument. Another question that was put by someone was regarding the format of the memorial. Jyoti Prakash explained that very well. We, the mooters community, generally name it as IRAC rule. I stands for issues, R stands for rules, and A stands for assessment of facts, and C stands for conclusion. This is the same flow that Jyoti Prakash has already told. I have just given it a name so that you can remember it, and whenever you start drafting it, this particular IRAC rule should be in your front side of the mind. Apart from that, one more thing that I will say to avoid lot of maxims. There are many writ petitions we see they would have used maxims, some kind of maxims in each para. So don't do that for memorials. It will look fancy and it will attract a lot of grilling. So try to avoid that. If you use inter alia, that is okay. We use arguendo for the sake of argument. You can use that. And there are certain maxims which are acceptable, but don't overburden your arguments advanced with a lot of maxims. Right. And
words, don't be a Latin master. Keep your arguments in English.
Yeah.
Don't try to convert your arguments in Latin or Roman. Yes.
Also, as Jyoti Prakash said, you have to keep it simple. You don't need to use literature. So you have to use very simple language. You have to think that the person sitting on the bench is a layman, and you have to make him understand the issue or the arguments or whatever point you are making. So you use simple, very simple words in your memorials. That will be easy for the examiner also to understand. And at the end, of after completion of your memorial, you should do a spell check and a grammar check, because there are certain circumstances when you will have misspelled something, or you would have done a grammatical mistake, and you would not be knowing that. So run a check on whole of your memorial, because sometimes memorial checker, if he finds out, then he will give you a negative marking. And I have seen teams losing mark on because of these grammatical mistakes and all. So you have to keep that aspect in your mind as well. Now, one more important thing regarding prayers. Everything said by Jyoti Prakash, you should follow that. Another thing that you should keep in mind is that when you write your prayer, you have to ask for specific reliefs. Now, not regarding specific relief act. Forget that. You have to ask specific reliefs. Now, what I mean when I say specific reliefs, I will give you an example. Suppose you are dealing with a writ petition, and you are saying that you are asking the court to invoke his writ jurisdiction, writ jurisdiction, and order a particular writ. Now, most of the students don't mention that which writ they want the court to invoke. Now, most of the cases that you will face would be mandamus. That is to order a public servant or order something, right, to do a particular thing. So you have to write specifically. After writing that the writ petition, the instant writ petition is maintainable. Just after that, mention the court issue the writ of mandamus against the respondent, or something like that. So you have to write your prayer specifically. Now, in case of criminal cases, if you want that accused should be punished with a particular amount of fine, there are many provisions which provide that accused shall be asked for or ordered to give a particular amount of fine. So you should specifically mention that, apart from saying that convict the accused of this crime. So these are some tricks which you should keep in mind. Now, if you are dealing with a civil case, and there the one party has sustained damages, sustained damage by the act of other party, then you should specifically say that rupees 50,000 or 50 lakhs compensation shall be given by the opposite party, right? So these are some specific prayers that I have said which you can use in types of cases. Rest depends on your facts of the case, and you have to think that what are all probable prayers that you can keep, and you should keep that. Because when I sit as a judge, even Jyoti Prakash, when he sits as a judge, we grill on jurisdiction a lot. So you have to keep that correct, and the prayer part a lot. So your prayer part should look perfect. Jyoti Prakash wants to say something. Yeah.
Yes. Another thing, when cases are clubbed, one example I gave, in a particular case, Mr. X versus Y. After that, another case is clubbed, where Y versus X comes to the fore. Okay, in a death penalty, for example, in a death penalty, Mr. X is the accused who has come in an appeal to the High Court against state, that is Y. So in the first case, it is X versus Y, tagged with the state appeal, that is Y versus X. So in the prayer, you have to be very definite. You have to be very particular as to which appeal you want the court to set aside. If you say that please set aside the appeal, the court will also set aside your appeal. That will be very much harmful to you. So if you want to set aside the appeal of the state, especially in the tagged matters, so you have to definitely say as to which particular appeal you want to get set aside. So be particular, be specific. Whatever you are trying to get from the court, explain it in simple and definite words. That is the crux of the relief section or the prayer. No need of literature. Keep it simple, keep it legal.
If you guys have any doubt, or if you want to say something, then you can say and we will address that. And after that, we will wrap wrap it up for today.
Sir, actually, I didn't wanted to say something. I don't have any doubt. I just wanted to say I'm very thankful to you, sir, for your time, because this is the first moot class where I understood something and nothing got over my head. So thank you very much for your time and patience.
We are really grateful for your presence, and we are really glad that you have understood almost what we have said. And if any time in future you face any doubt, you can contact any of us, and we will be happy. We will be overwhelmed to address those doubts as well. So not a problem. Thank you.
So I should take
Thank
the
you so
name:
much.
Amisa, Divyasri, Neha, Vaishnavi, Vaishnupriya, Vaibhav. These are the great people. Thank you for your patience. Really, it is really hard to sit for 5 hours, because we are motivated by our own concepts. We are addressing, so we are remaining active. But sitting idly and listening to a speaker, it is really a very hard job. And you people have done a wonderful job. Thank you for appreciating our efforts. We are grateful.
Okay, I would also like to add something. Yeah, I also don't have any doubt, and it was really an enlightening session. And hats off to both of you for such a wonderful initiative, because I really wish when I was in first year, I could have got all this knowledge and everything. But sadly, I'm in final year now, only one more moot, I believe. In the next semester, we have our moot court in the college, so we won't be able to participate. So yeah, I hope in upcoming moot court competition that I am participating right now, it will be really helpful. And yes, it's really an enlightening session for us. So thank you very much.
Thank you. Thank you.
You are a great mooter, I must say. You're a great mooter. Thank you, Neha.
Thank you.
All right, then we should wrap up this session and we will end the meeting. Also, if you guys want to refer to any of the things that we have said, you can check the YouTube link that I have already given 2-3 times on our WhatsApp group, and it is there on YouTube. We will segregate that and upload that later, but let it be there on YouTube. You guys can refer that, and if you want to understand something, you can understand that from there. If you face any further question, you can put it on the group. Group is open, so we will address that. So all the best for your upcoming moots as of now, and have a great evening. Evening is already over. Still have a great evening.
Yes,
Thank
we will
you
let
so
you
much.
know. So we will let you know what will be the time for tomorrow's session in the group itself. Stay in the group.
Thank you so much, sir.
Thank
Thank
you, sir.
you.
Thank you. Thank you.
Thanks.
Thank you,
Thanks.
sir.
Good night.
Have a good night, sir.
Good night. Good night. Please leave the session. We will end it. Yes.
ମୁଁ କହୁଥିଲି ନା ହବନି ଟାଇମ୍।
ଲାଇଭ୍ ଷ୍ଟ୍ରିମିଂ ବନ୍ଦ ଅଛି।
Wait.